Please go. Sir, I will mention for item number 14.
I think you have to put your microphone on. Just
Madam, I will mention for item number 14. Madam.
14. Question 17 matters. Why should it be adjourned?
Madam, 17 minutes, my lord. After getting the interim order, my lord, they are not cooperate with me, so I have to contact some instruction required. So, matter may kindly be adjourned
No,
for 2 weeks. Madam.
then we do one thing, we vacate the interim order. Keep it pending. Let them come forward to the court.
The matter is this, my lord.
Say,
My lord, my lord.
it's now 6 years gone by.
My lord.
You are having the advantage of an interim protection from the court.
My lord.
Now your client is not cooperating with you.
My lord.
Thinking that let it happen, whatever it happens. I'm enjoying an interim order. If I don't appear, the hearing will not take place. I'll enjoy the interim order. If because of this approach, we'll vacate the interim order. And
So
you also take action after the interim order is vacated. Once this is done, your client will definitely come forward to the court to argue his case. Otherwise, suppose we allow you to withdraw, what will we do with this matter now?
And last chance may be given, my lord, 1 week's time may at least given.
1 week time.
I
Strictly 1 week time, either you argue the matter or we vacate the interim order. We cannot allow somebody to take advantage of an interim order of the court. Undue advantage. That will be not permissible.
denial.
To accommodate you personally, we allow you 1 week. And in 1 week, you do whatever you want to do.
After 1 week.
Because this will be a dangerous trend. Take an interim order, disappear.
My lord.
So that the court can neither hear the matter, no, and I'll enjoy the interim order forever. It can't be. Your name, please?
B. Islam. My lord.
B. Islam. Adjourn on the prayer of Mr. B. Islam to be listed on next week, fixed date.
18th.
No further adjournment
Deep.
to be granted.
You go.
Item 1 for motion.
Yes. Item 1. Order of 18/1/2023
My lord, explain.
produce any material which will show that Abdul Malik is the father of the petitioner. Please produce it.
My lord.
A order to the Khaji also. Please read the order of 18/1/2023. Please read that order.
My
Produce the material which will show.
Yes, my lord, my lord. Annexer 1 in additional affidavit, my lord,
Page number
page number 35, my lord,
35.
voter list 1996.
Nineteen 96 village Havilia.
35 and 36.
Who is the father? Malik.
Abdul
Abdul
Malik.
Malik.
Great grandfather
Eh,
and grandfather's name is enlisted in voter list 66, my lord.
Page number
Page number 36, 35 and 36.
35. and
Translated.
30. What are you submitting, Mr. Mohammed?
Father also. Next, 70 grandfather, 1970 voter list grandfather, and
No, no, we are,
then my lord,
Mr. Muhammad, you are stating in a very
1989.
confused manner. Please bring some clarity in your submission. If you are saying somebody is the grandfather, which page the name appears? Please point out that.
my lord, page number 35.
35.
Yes, my
Page
lord.
number 35 is a voter list of 1966.
66. Enlisted
And
Grand-
who is the grandfather?
grandfather, my lord,
Name of the grandfather?
Abdul Kader Mandal.
Abdul Qadir Mondol is the grandfather. Now, who is the father?
Father, my lord, Malek Mandal.
Page number?
Page number, my lord, 89. Page number 39.
Page number
39.
39.
Voter list 1989.
39. Just a minute.
89. A. Malek Mandal. Father,
Father is A.
Qadir.
Malik Mondol, son of A. Qadir. Okay. Now, which document will show that this petitioner is the daughter of A.
Petitioner,
Khalik
my
Mondol?
my lord. Petitioner, my lord, there is Kazi Mary's voter
No, please,
PAN card and
Mr.
school certificate.
Mr.
my lord.
Muhammad, please
I-
refer to the page number where that
Page-
document is
Page
available.
number, my lord, 51,
51.
Kazi Mary's, my lord.
51. Qazi. Mr. Sharma. interim auditor.
Miss Maleka,
Mr. Sharma, the admit and pass an interim order. Heard Mr. T. Mohammed and counsel for the petitioner also heard. So, the notice 6 weeks, extra copies 3 days. Where is the order of the tribunal? Page number?
page number
Hmm,
19.
Page number 19. Call for the records of FT, case number FT 5th 321 stroke 2017 from the Foreigners Tribunal number 5, Borpeta. In the writ proceeding, the petitioner relies on the voters list of 1966 of village Haldia, which contains the name of Abdul Qadir Mandal, son of Ansab Mandal at serial 167, and claims that Abdul Qadir Mandal is the grandfather of the petitioner. Thereupon, reliance is placed on the voters list of 1989 of village Haldia, which contains the name of A. Malik Mandal, son of A. Qadir, and it is claimed that A. Malik Mandal is the father of the petitioner. Thereupon, reliance is placed on the Kabin Nama as regards the marriage, Kabin Nama, which contains the information that Maleka Khatun is the daughter of Abdul Malik of village Haldia. Accordingly, the petitioner claims that the burden under section 9 had been discharged on being prima facie satisfied. Rest in the order.
2 and 3 for admission.
May it please your lordships. Your lordships, this matter pertains to detention of certain some Rohingya refugees, your lordship.
Sorry.
I,
Pertains to
detention of Rohingya refugees, your lordship. I am appearing in item number
Rohingya
3.
refugees. 2017.
I mean, item number 3, your lordship.
Sorry. Which one you want us to refer? Item 2 or item 3?
Item 3, your lordship.
Lordship,
up-
uh, in item two, Lordship, they have alleged because they are the already the DFN's Lordship, and they have been shifted to the Matia camp Lordship. So all of them are belonging their Lordship. So in item number two, Lordship, they have alleged that proper care is not been taken. So Lordship has called for a status Lordship, which I have brought in this matter.
But
And,
he is urging item 3.
in item three, actually, they are.
You are in item 2.
Item two, yes, Your Lordship.
Item 2 is for what purpose? What is the prayer in item 2?
Hmm.
Hmm. Why nature of habeas corpus? Is
Yes,
somebody detaining you?
Lordship, my senior is in hospital due to his medical
Senior is in
emergency.
hospital, so
He instructed me to take pass over the matter for the day.
pass over for the day.
Yes, Your Lordship. He has some medical emergency.
Then Passover will be difficult. Lordship may take it on some other day, Lordship.
What do you mean by Passover? Passover or adjournment?
Adjournment for the day.
Passover, we don't pass any order. We just keep it aside for the time being. Adjournment will pass a order to matter to be adjourned. You want adjournment?
Yes, Your Lordship.
On which date you want the matter to be listed?
Lordship, after 2 weeks,
Who is your senior?
Who is your senior? Get the name.
MD I Hussain, Your Lordship.
Sorry,
I Hussain, Your Lordship.
M.I. Hussain does not appear in this matter.
Yes, Your Lordship.
M.I. Hussain appear for him. He doesn't appear in this matter.
I Hussain.
I. Hussain.
Yes, Your Lordship.
It stated that Mr. I. Hussain, learned counsel of petitioner, is having some medical inconvenience and accordingly adjournment is up for adjournment allowed list on later.
Highly obliged, Your Lordship.
Yes, item 3 now.
Your Lordship, in item number 3, the Honorable Court had directed.
This is a writ appeal.
Yes, Your Lordship.
And why are the two matters tagged together?
Both are Lordship, they are the.
Rohingya.
Yes,
Yes, sir.
So Rohingya is the only common word.
yes.
Are the legal issues same?
Legal issues, almost same, Lordship. Item number two actually tagged with item number three initially, Lordship. Now, because the matters are almost similar, but in this case, we are taking it up as a in writ appeal, Lordship, item number three, where actually they were already
Writ
convicted
appeal
and
means there
yes.
must be a proceeding before the.
Yes, Lordship, there was proceedings, Lordship.
What was the
and-
writ petition for?
Your Lordship, the writ petition was praying for writ of habeas corpus and compliance with the SOP of the Union government.
Habeas corpus.
Yes, Your Lordship.
Why habeas corpus?
Because Your Lordship, they are under detention presently at Gwalpara Detention Center.
No, is the detention under the law or the detention is without sanction of law?
Your Lordship, what happened is that they were convicted in item number.
Mr. Dey, please answer. In order for maintainability of a habeas corpus, the detention must be without authority of law. So first, answer the question whether this detention is under some authority of law or it is without any authority of law.
Lordship, my humble submission is that.
If it is
without-
with authority of law, but the law is wrongly invoked, then it will be a case for you to challenge that action. It cannot be habeas corpus. Okay, but if the detention is without authority of law, then it will be habeas corpus. So first, make up your mind. What do you want to submit?
My lord, my humble submission is that it was without the authority of law.
Why?
Because
Where is the detention order? Let us see.
there is no order, Your Lordship, because we completed our,
There is no order.
we completed our conviction period, Your Lordship. this
Okay, you
sentence,
were convicted, the period of conviction is over.
Lordship.
So now what do you want to do?
Thereafter, we have been kept under detention. Your
Okay,
Lordship.
we'll release you from detention. You go back to the place from where you came from. You voluntarily go back, you'll be released from detention. But otherwise, where will you stay? If you are not, you can't freely move around in the country. at the same time saying that I'm not going back also to my own place.
Yes, your lord.
Both can't go together.
Yes, your lordship. For that, there is,
So you give an undertaking, they'll escort you to the place wherever you want to be escorted. You'll be released, you go back.
your lordship, we have actually, there is a procedure of the union government. There is a standard operating.
So
procedure.
therefore, this must be a writ petition of some other order claiming another kind of a legal right, either under the international law or under the national law or under the Constitution of India, that this is my legal right. Please restore the legal right.
Yes, your lordship.
You can't swim around in the ocean without any direction.
Lordship.
What decision will you render?
That's why your lordship, by.
That's why we are asking Mr. Day, formulate your case, what you want first, so that we can apply our mind. They can also respond to it.
Lordship, there is a standard operating procedure that the honorable court had directed that be complied with by order dated 13/3/2023, your lord.
What is standard operating procedure? For what?
For grant of long-term visa to persons who claim to be refugees, your lordship.
For grant of long-term visa, do you have a passport?
Lordship, no.
Then visa is related to passport.
Lordship, because
Mr. Day, only exuberance will not lead you anywhere. First, you see who are these people, what kind of legal right you have, what kind of right had been violated. Please tell us, we'll attend to it.
Lordship.
But you can't say that I demand this, I demand that, give me everything. There is a difference between claiming a legal right and making a demand. So you segregate your demand from your legal rights and present only the legal rights before the court.
Lordship.
Demand has to be before some other authority. Court of law are not for the purpose of attending to demand of the people. There's a distinction. We look into only rights, legal rights. So you present your legal rights, we'll examine, we'll ask them, we'll have their response also.
Lordship, that the
See, there is a difference between the two. A man may say, I'm a very poor person, I demand rupees 1 lakh from the authorities because I have to meet my needs. This is a demand. There is a particular scheme or something, some provision of law which provides from grant of some amount to people having less money. You have applied, they are not giving. This is a right. So you formulate your argument.
Lordship, here also we have applied. The status of our application is pending.
Applied under what law?
The
If the
standard.
law provides only, then your application is valid.
Lordship, the
Mr. Day, in other words, please prepare thoroughly. These are serious matters. You are taking the responsibility of a huge number of people. Formulate your point, find out the legal rights, present it before the court, will adjudicate it.
Lordship may kindly peruse order dated 13/3/2023.
Will not peruse anything. Because first, to peruse that order, you have to tell us what kind of SOP and under what legal right. SOP you say regarding some visa. Now, if you expect the court to direct them issue visa to these people, before that, we'll have to look into the law of visa, under what circumstance visa is issued, to whom visa is issued. That's why we expressed there's a difference between a demand and claiming a legal right. If you're ready, you argue. If you're not ready, we'll fix a date. Come fully prepared. But the argument must be broad-based on the entire gamut of the law applicable.
Lordship. The SOP is on record, your lordship. I have, it was. taken-
First, you have to answer the question, the SOP. The SOP, we heard you said for giving long-term visa.
Lordship.
Under what provision of law? SOP is only a procedure. SOP is something like the TPC, how a case has to be filed. SOP, standard operating procedure, it's only lays down the procedure. But to whom the procedure will be applicable and that it is applicable to you also, first you have to satisfy that.
Lordship, this, if I may submit your lordship. If I may submit your lordship.
Are you ready or you are not ready? Not in piecemeal.
Lordship may. Lordship,
Piecemeal is a wastage of time. If you're ready, you argue. If you're not ready, you tell us when you will be ready.
Lordship may take it on a different date, your lordship.
Different way.
After 2 weeks.
See, these are serious issues. And one decision will disturb the entire equilibrium in respect of many other people. So we'll hear you. Not only hear you, a complete hearing, a detailed hearing.
Lordship, the honorable court had directed me, directed the union government.
See, we are not hearing part by part on every day. That other day something happened, today you continue from that. We'll hear you from the beginning. We'll hear you from the beginning. Tell us who are these people, what kind of legal right they have, what kind of right had been violated.
Lordship.
We'll examine it. If your right is there, right is violated, definitely there will be a direction.
Lordship.
Yes, Madam Ghosh, you are also there in this matter. Your
Lordship,
name also appears.
Lordship.
You also here. Or
He will argue this matter.
you can see your name also in the
Yes,
list.
yes.
No, it will be serious, serious issue. Yes. Are these people citizens?
No.
No. They are citizens of some other country.
Yes, your lordship.
They are here as refugees.
Yes.
Where is the refugee certificate?
That we have applied for the UNHCR.
Lordship will find it at page number
Page number?
272 to 275.
No, show us one certificate. Respect of, there are number of people. At least
272, your lordship.
page 72. '72 is some first information, part of some first information report.
272, your lordship.
272,
Yes.
okay. See, during her stay in India, the bearer is subject to and has the obligation to respect the national laws. So you cannot go beyond the national laws. Mr. Chaudhary, this is issued by the UNHCR refugee card receipt. Is the government of India accepting it?
Lordship, no, because India is not a signatory to the refugee.
No, that's why I'm putting, possibly under that UN resolution, India is not a signatory.
Not a signatory.
So you are not accepting it.
No.
So if they are not accepting it, you can't impose it on the government of India by getting a card from some organization, maybe UN, if it is not recognized in this country.
And the application is on
Lordship, they have their own procedure, your lordship, the union
Who?
government, the union government,
So you approach the Indian government first
you have your.
with an application that please accept our status as a refugee. The day Indian government accepts it, then you will be governed by the laws relating to refugees.
We have
But
done
can
that.
a court of law compel them to accept it? Can you issue a direction to the Indian government of India that you have to accept it?
We have applied, your lordship.
We may have applied.
Yes.
Will it be within the jurisdiction of a court under 226?
That application is pending, your lordship.
Mr. Dev, we understand. You don't have to repeat before us. But the implication will be that this is an even HCR refugee card. They are not accepting it. Now you are seeking a direction from the writ court that you accept it. Does the writ court has the jurisdiction to pass such kind of an order?
Lordship, we applied as per the direction of this.
Mr.
honorable
Day,
court.
you may have done many other things. Please answer the question. Your making an application itself is not sufficient. We often give you one example. Suppose you make an application to the deputy commissioner, I want to murder X. Now you come to the court and say, pass an order in my application. Will it be maintainable? No. Why? Because the subject matter in the application may not be supported by law. This is the principle of a court issuing a direction to consider an application. So if you had made an application, first you have to show that a legal right is being claimed in that application. Only then it will be followed by a court order that consider it. Otherwise, a writ court cannot be converted to a forum where the government of India will be directed to do something which under the law they are not obliged to do so.
My lord,
Think a little in larger terms, not just with a narrow periscope of I want to give relief to my client.
Yes.
And by this means or that means. And it's a very serious law. International principle of international law is applicable, national law is applicable, constitution is applicable, the policy stand of the government of India is applicable. You just can't bulldoze everything and say that you have to give this to us. Some temporary relief we can give you here and there. That don't violate the human rights. That is another factor. But claiming something more or permanent in nature is a different factor. Suppose the condition you are in now, it violates some human rights. That will be corrected. We can always direct them. That don't violate any human rights. Give them the basic human treatment. Understood?
lordship.
So you have to make a more broad-based argument now. Yes, Madam Ghosh.
Yes, actually, we will.
You go
discuss,
through the
yes.
law, go through the relevant provisions, try to find out under which provision you think that some legal right flows in favor of this category of
Yes,
people.
Lordship.
Place it before the court. We'll definitely put it across to the respondents.
Yes, Lordship.
Tomorrow, what will happen? Suppose an enemy alien manages one such kind of a certificate, even as a refugee card receipt, comes to the country and now say that you have to give us everything now. We are holding a card.
We will submit our on the next week.
Sorry.
2 weeks time we will take. So within 2 weeks, we'll prepare ourselves and we'll submit it.
These are
Yes, Lordship.
much larger issues. It's not just can't be projected only through a narrow prism that they are people who are here, they'll stay here for some time, give them everything now. And don't disturb them in any manner. So that means anybody from this world has a legal right to claim everything in this country. Where will the country go? And is the reciprocating facility made available to Indians elsewhere? Tomorrow, suppose you are not very happy to remain in India, will any other country accommodate you in this manner? Let me try it in the USA, let me try in Japan, let me try in some country where it will be a better, you think it will be a better living, although it may not be a better living. Does anybody has any reciprocating arrangement? No, I don't think. Every country is strict in their national laws.
We'll take 2 weeks
But
time.
on the other hand, if you want to confine yourself only to the basic principles of human rights, that is another matter. We'll definitely ask them.
Only as-
And that should be backed by specific instances in what manner human right has been violated. That will be restored immediately. Yes, Mr. Agadi Chaudhary. Basically, what are the views of the,
Lordship,
where is the order of the learned single judge?
Learned single judge order, Lordship will find it page 266. It starts at 255, 265. Lordship will see page 266 onwards.
Came to India in the year 2002. Why are they still here?
They say that they have come in 2002
Was settled in the detention and still here.
and. Now on the. prayers-
See, some time back, we read in the newspaper that in UK, one person from India, he happened to overstay his visa, simply disappeared, became himself unavailable for the authorities. The authorities found him out, picked him up in the middle of the night, took him to the airport, put him in the next plane to India. Go back. This is how other countries are treating the Indians when they try to do this. Why should the reciprocating basis be something different that we are open to everybody, whole of the world?
Lordship.
If you want the rights, you apply yourself for citizenship under the law. If you are eligible, you will be granted.
Should we take it up after 2 weeks?
And the detention center means what kind of a premises it is? Some jail.
No, now they are in this Goalpara detention center. What they wanted was in the writ petition that they should be allowed to go to Kashmir, where they say some of their relatives are.
So you bring a letter of authority from the government of Kashmir, they'll send you.
That I have taken it up with the authority. Lordship.
They'll send you there. If Kashmir is welcoming you, they'll send you. Assam will send you.
It's taken up from the government level, Lordship, but they simply denied, Lordship.
Who?
The Chief Secretary of.
Of Jammu and Kashmir.
Lordship.
If they don't accept
Yes,
you,
Lordship.
how can the authorities in the state of Assam do it?
My lord, that was not the prayer in the writ petition.
Sorry.
That was not the prayer in the writ petition.
Lordship will come to the prayer in the writ petition. If we-
Mr. Day, you have the habit of arguing here and there.
Page 61.
But we did not lead you anywhere. These petty things, not prayer, this, that, leave aside. Address the larger issue, larger legal issue.
Lordship.
And what is your prayer in the writ petition? If you're so interested in the prayer, what is the prayer?
861.
Let us look at your prayer.
Page 29, your lordship.
Please read it.
21. Into that writ petition, they say.
Writ appeal.
Writ appeal. The writ petition of.
Prayer in the writ appeal or
Prayer.
prayer in the writ petition?
Writ petition prayer is at page 61.
Yes.
We want the writ petition prayer, not the writ appeal. You cannot make a different prayer in the writ appeal.
In writ petition, they have to stand lordship to send them to Jammu and Kashmir.
Then why did you make an incorrect statement? Then that is not my prayer.
Lordship, that I apologize, your lordship. because-
Don't, please don't. Don't misdirect the court.
Lordship. I apologize, your lordship, sincerely apologize. Because I honestly.
So now if your prayer is that you should be sent to Jammu and Kashmir, you are seeking a direction from the court. As you have filed in Guwahati High Court means some direction to the government of Assam will also be involved. Jammu and Kashmir, if they are welcome you, they will send it. Get that authority of letter from Jammu and Kashmir that you are welcome there. We'll take note of it and ask them to, you pay for the cost, they'll arrange for the transportation, they'll go there.
Jammu and Kashmir has refused to take us. Sir.
Then how can a court issue a direction to the to another state if they are unwilling? Then you file a writ petition in a Jammu and Kashmir High Court seeking a direction to the government of Jammu and Kashmir that allow this us to enter here. They can only decide. And if you have a favorable order, come back to us. We'll direct them to provide you the transport to go to Jammu and Kashmir. In other words, where do you stand? We are yet to understand.
Lordship, there
Who
is-
are these people and where do they stand under the law?
Lordship, if your lordship kindly peruses the standard operating procedure once, your lordship.
We are not going to do it. We have told you.
Lordship.
Procedure is only a procedure. Procedure does not give any legal right to anybody. Right flows from somewhere else. Once someone has a legal right, then what procedure is to be adopted to implement that right is provided in a SOP. SOP is not the source of a legal right. Understood?
Lord.
That's right. No SOP can grant any legal right to anybody. That decision or the provision to have a legal right has to be on basis of something else. An SOP will only provide the guideline how to implement that legal right. So within this broad parameters, you please argue or
Lordship.
and that's your only prayer to go to Jammu and Kashmir.
No, your lord.
What more you want?
Lordship, because our prayers, your lordship, that the SOP be, the long-term visa SOP.
We have already responded. SOP is only a procedure, not the source of a legal right. Even page 61 does not contain any SOP. Where is the SOP? You are so interested. Let us look at it also.
Lordship, the earlier SOP.
No,
is
SOP, applicable SOP. Don't go to
applicable
jail.
SOP is on record, your lordship.
Not on record.
We had submitted it before the honorable court on on 13/3, it was submitted. Your
So
lordship.
you are not going to submit it
I
once again.
have another copy.
Let us look at it. What's the date of the order you are referring?
13/3/2023, your lordship.
13/3/2023. In the light of the SOP dated 20 March. Yes, let us see where is 20 March.
Lordship, that is the
This
one.
is 20
Yes.
March. Mr. Takeri Chaudhary, this is the standard of operating procedure to be followed whenever FRO comes across foreign nationals who claim to be refugees. Are you agreeing they are refugees?
He just cannot claim to be a refugee.
No, but your SOP says who claim to be refugees, who may not be refugee also. On your own, you have bound yourself. So they are trying to take advantage of it. Oh, yes. We'll hand over you over this one.
No, yes.
Mr. Day, I think you were referring to page 272 to claim that you are a refugee.
Yes, your lordship, that is.
I think just no, 252 to claim to be a refugee. Yes, 252. There are number of them are there. So now if you look at the date,
That is.
no, just one. If you look at the date, it is 26 October 2021. Come to page 252. It's in respect of one of these petitioners. 26/2/2021. It is your own statement before the learned single judge that you have entered India in 2002.
Lordship.
So from 2002 up to this date, you are an illegal migrant,
Lordship,
definitely, by your own statements.
in 2009, your lordship, the first time cards were granted to us, and
That means up to the grant of the card, you are an illegal migrant.
Lordship.
Now, if you look at the SOP, the documents available with the foreigner issued by anybody either in India or abroad will also be taken into consideration. And this is the SOP to be followed whenever FRO comes across foreign nationals who claim to be refugees. That means you must have entered the country as a refugee. To have the benefit of this SOP, your first entry into the country must be as a refugee. That refugee status will be given to you either by anybody, any authority in India or some authority abroad. Means before entering the country, you obtain that authority, that status as a refugee. And once you come into this country, you'll be subjected to this SOP. Now, after staying for 20 years as an illegal person, just getting hold of a document from some authority will not convert you to a refugee overnight.
Lordship, actually, they
What
are,
is a refugee?
Lordship, the community of Rohingyas in Myanmar are oppressed. Your Lordship,
Doesn't
and
matter. So the Rohingyas must have first reported before the authority in India, claiming that we are persecuted there, please give us entry as a refugee. That is a precursor to the whole thing. Not that you remain as an illegal person for 20 years and then try to attain a different status. And after changing your status, after 20 years, then come and claim that no SOP, give me everything now. So have you realized what you have done? First 20 years, absolute illegality. 2021, get hold of one person somewhere, get one card. Now you say my status is changed to that of refugee. And once you change to that of refugee, now you rely on the SOP, give me long-term visa. So an illegality is being slowly, step by step, being converted, sought to be converted into an illegality. And now we are one day a court direction for that.
Actually, Your Lordship, these people are barely literate, Your Lordship, and the UNHCR has its office.
Mr.
in Delhi.
J, these has no basis in a court of law. That I have committed illegality because I was illiterate.
For that, they have been convicted, Your Lordship, and their sentence is over. Here.
So after conviction, you take your own course, whatever you required to do. If you want to go back, we'll direct them to provide you every facility.
Lordship, because the state of Myanmar is not taking us, Your Lordship.
No.
Lordship, they have provided the wrong address, Lordship. The Ministry of External Affairs, that is from the state of Assam, it was taken there.
Sorry, this benefit can't be given to these people.
No, Your Lordship, because the state of Myanmar has to confirm our address. We provided the right address, but our village was burnt, Your Lordship.
So what?
And we have proof of that.
So you go back to your country, claim your rights there.
And Myanmar refused
See,
to.
And
acknowledge
when
the
was it
village.
burned? Was it burned in 2002? No. It must have been burned about a few years back. So how can a subsequent happening legitimize an earlier illegality? Suppose you would have been a fresh refugee from that burnt village that we are persecuted, come to the border, make a request to the Indian authorities, allow us the refugee status. You are a genuine person. We can direct the government of India to consider that case. But here is a case, gross illegality of 20 years is now sought to be legitimized. And if you are not there back in your country, how do you know what is happening there now?
Lordship, the UN reports I have annexed.
Even report may not be applicable to you. It may be applicable to those persons who had faced persecution there.
Rohingyas are systematically oppressed since long time, your lordship.
So you mean to say entire Rohingya has now to be accommodated in India?
No, your lordship.
Then this is an absurd submission.
Lordship, there is a possibility of third country deportation also, your lordship. So
Carry ahead. You communicate with the third countries, inform us, we'll direct them to do it. Get it done. Mr. Have they been processing their application to third country? They're referring to some third country they want to go.
So oral submission made.
Make an application, give it to Mr. Rakedi Chaudhary, he'll put it up.
lordship, that third country comes also is included in this SOP, your lordship.
Very well, make that application.
We have your
You identified a third country where you want to go.
we
Which
have-
country will take you?
Lordship,
Whichever country will take you, you feel so, make an application, we'll direct the government of India in the External Affairs Minister to put up that application before the embassy of that country. If they accept, they'll escort you to enable you to go to that country. That facility will also be given. But things can't be vague and directionless. Okay, should we record that order? You want to go to a third country?
no, your lordship, our application under this SOP is.
Sorry, first you have to satisfy. We may recall our order also.
Lordship,
Our order was passed only to consider. That's all.
that is pending, your lordship.
Let it remain pending. Now we don't see any legal right for that also. Why should we proceed further? That day it was a casual statement from the petitioner and the court said, yes, you want to go, you go. But today you are seeking a more further direction. We are definitely going to look deeper into the matter.
I'm not seeking any direction, your lordship. I'm just
Then,
saying this.
then why are you before the court? Then we close it.
This,
If 13.3 is the final order, you are satisfied. Let us close the writ appeal then. We believe a matter is pending because we want some further orders from the court.
Your lordships wanted to see what application, how is it, the result of the process.
Why? First you satisfied your legal rights.
Lordship will argue it after 2 weeks if your lordships permit.
What will you argue? If you want to go to a third country, we'll facilitate that. India is not a very good friendly country for you. We want to go to some other countries. If you feel that so. This SOP is applicable only to those class of refugees who had either been provided documents of a refugee by the authorities in India or who were provided documents by an authority abroad, means outside India. I don't think it covers the category who will illegally remain in the country for 20 years, then obtain one document from somebody, change their status now to a refugee, the illegality is gone, they now become refugee. Then now trying to go into the next stage of having a long-term visa, means everything is legitimized now. This is where we are little concerned, if we allow it.
Lordship may produce this press release once because it says that the union government relies on the expertise of the UNHCR to register refugees.
Make them. First, you get your refugee status from them. We'll entertain after that. approach the government of India. If they want to give you refugee status, in spite of it, it's your decision.
There is-
And once we
There is
have
no
the
question.
document, we'll definitely follow the SOP. But decisions cannot be obtained in an indirect way by getting orders from the court one after the other. That will be overreaching the system.
This is a case lordship, they are gradually developing.
Step by step. That's why I say
That's,
for 20 years, gross illegality. Get a document in 2021. Whether that is acceptable or not is also another factor. Now you say SOP and long-term visa. Long-term visa is for the lifetime for you.
No,
So what happened to that illegality? And moreover, this SOP is for another category of people. Suppose somebody had been recently subjected to persecution. They will come to the Indian border and make a request. Allow us in as a refugee. And they agree. Once they agree, this SOP is applicable.
from the prayers lordship, since in a writ appeal, they cannot widen the prayers. From the prayers making the writ petition.
No, we are allowing them to do everything. Widen it as far as you want. Still, it has to be
Yes,
backed
yes,
by
it
some
has to be
provisions of
within
law.
some legal limits.
The more documents you are taking us to, more and more it's going against you. Mr. Day and Madam Ghosh. In other words, a court of law cannot convert a gross illegality into a legality. That will be travesty of justice. That should not be encouraged. And what is the implication of a law of a man being convicted for any violation of these kind of laws, for remaining illegality in the country? The end of the conviction is you go back from where you have come. Not to change the illegality into a legality.
It takes 2 weeks time, lordship, and then we address on this issue.
After hearing the learned counsel for the petitioner in detail, certain questions have arisen for consideration. It is an admitted position of the petitioners that they had entered India sometime in the year 2002 and claims to have been residing in the state of Jammu and Kashmir. And thereafter, they were detected in the state of Assam and were prosecuted under the relevant laws applicable to foreigners. After completing the sentence upon being convicted for such offense, the petitioners are now being placed in a detention camp. At this stage, in the writ appeal, the petitioners are now making a claim that they are to be subjected to the standard operating procedure to be followed to deal with foreign nationals who claim to be refugees. As the petitioners are claiming benefit under the SOP applicable for refugees, the most relevant and pertinent question was put to the petitioners as to which document would indicate that they are refugees. certain UNHCR refugee card receipts are being referred. A reading of such UNHCR refugee card receipt indicates that they were printed on 26/10/2021. A reading of the aforesaid facts clearly indicates that from the year 2002, when they entered India for the first time, up to 26/10/2021, they were all illegal. They had illegally entered the country and had also illegally stayed in the country. Mr. S. Day, learned counsel for the petitioner, refers to clause 2 of the SOP referred above, which provides that where documents are available with the foreigner issued by anybody either in India or abroad, will also be taken as inputs in arriving at a conclusion by the FRRO concerned. In other words, the SOP is applicable to such class of foreign nationals who have documents available with them indicating that they are refugees, which would have to be issued either by an authority in India or abroad. A prima facie reading itself makes it discernible that such documents indicating that they are refugees would have to be available or made available at the point of entry into India. Full stop. In the circumstance, a question is required to be answered by the petitioner as to how the period of illegal stay in the entry and stay in the country from 2002 up to 26/10/2021 can now be sought to be legitimized by relying upon an UNHCR refugee card receipt and based upon it claim the provisions of the SOP referred above. On the prayer of Mr. S. D. Langan, the petitioner, matters stand adjourned for further hearing on so and so heard in part.
One small thing I would like to just state is that UNHCR card is valid for 2 years and they subsequently.
Show us the first one.
First one is which is the.
Was it
indicator.
available in 2002?
UNHCR number 30509 is indicative of the first year registration.
So we have to get a letter from UNHCR to show that.
This is what is indicated
2000
we have recorded.
Yes, Lordship, because it's
2011. No?
Sorry.
2011. was issued.
It's as we pointed out by
2000
MSD Ghosh, learned counsel for the petitioner, that the first of the UNHCR refugee card receipt was made available to the petitioner sometime in the year 2011.
nine. Initial
to-
card was in
In
nine.
the year, in the year 2009. Even
can
if it
get
is
the-
so,
We can
still,
the endorsement.
there would remain a period of illegal entry and stay in the country from 2002 to 2009.
Okay, that is-
And in such circumstance also, a question would arise as to whether the SOP, provisions of the SOP would be applicable to such class of people who will remain and will enter and remain illegally in the country for a considerable period of time and thereafter claim a status of a refugee. Did you inform the UNHRC about your antecedents? I don't think so.
This,
That we have
Yes, it's
illegally entered in 2002. I don't think so. They have not just gone there and taken a regulation card as if they are entering for the first time.
That instruction I'll take from UNHCR lordship. UNHCR instruction.
And UNHCR also, do you recognize?
Since we
It's,
do not recognize.
And Mr. RKD Chaudhary, learned DYSGI, on the other hand, has stated before the court that the UNHCR refugee receipt card relied upon by the petitioner is not recognized by the government of India, meaning thereby that the status of refugee claimed by the petitioner itself is not recognized.
May I submit lordship?
Lordship, India is not a signatory to that, Lordship.
Sorry.
India is not a signatory to
And Madam
UNHCR.
M. Bhattacharjee adds that India is not
May I
even a
submit
signatory.
May I submit lordship? Ministry of Home Affairs, they state that there are 4 countries where refugee comes from is Afghanistan, Myanmar, Sri Lanka, Tibet. So, and they allow refugees are registered under the mandate of United Nations High Commissioner of Refugees, that UNHCR, who meets regularly with all the refugees.
So
and
registration
their-
by the government of India.
Not
Get that
UNHCR.
registration.
It's the UNHCR.
Registration by the government of India.
As
registration.
per the recommendation,
As per their recommendation, government of India registers. Get that
So,
registration.
so they
Get the
register.
registration of the government of India. Definitely will be included.
Yes, Lordship.
Let's also for a hearing.
25th May. Item 4,
Yes, so we can correct your point. Wow. See, there's a difference between claiming some immediate relief on the basis of human rights that give us the treatment of a human being, and claiming rights which will ultimately legitimize an illegality and make you a person to legitimately remain in the country. There are 2 different aspects, totally different aspects. And both can't be mixed up with one another and just you keep on making claims after claim. If we suppose we pass a judicial pronouncement to that extent, the country will be at difficulty, the security will be in difficulty of the country. And that too, if you feel that the government of India has no role in it, we'll just get a document from some authority and we'll have everything in the country. What will happen if an enemy alien does it? Just come with a similar document, and absolute enemy alien who is planted to cause subversive acts in the country comes with this document and makes the similar submission that this is a SOP, now give me long-term visa. Who will protect the security of the country? And our judgment will be, mind you, it will be the law henceforth. Everybody will quote that this is a judgment of Guwahati High Court. We are entitled to. We have to think a little in broader terms. Nothing prevents. Suppose you refer to 4 countries. A subversive element is planted by any of those 4 countries. Go to the UNHCR, get this page 252 kind of a document. Then come to the High Court, say SOP. Now give me long-term visa. So man will remain in India all the time. Have you thought a little deeper? So that's why you're saying claiming this kind of permanent right to remain in another country and claiming basic human rights are absolutely 2 separable and distinct claims. Please look into the law.
may I please your lordship? In this case, the petitioner number 1, he died.
Mhm.
So
Item number 4.
Yes, Lordship. Yeah, Lordship.
আর রেফারেন্সটা বাকিটা আমার নাই করব Does the UN have their own facilities for keeping refugees anywhere?
United Nation.
They are the UN human rights something. Do they
declare-
maintain any of their own facilities anywhere?
Facilities UN.
Conventions.
That convention, India is not the signatory.
No. Otherwise, do they maintain any facility anywhere? No,
I don't think so. I don't think so.
but they'll impose on some other country by just issuing one document. Hmm.
But I'll just have to check it, Lordship,
Just check
without
up.
checking also.
If
making
they
submission
recognize
on
these
paper,
people to be
that-
refugees from 21 or say 2009 as you claim,
Yes, Lordship.
if they have their facilities, let them take charge of them. Hmm. No? The government of India says we don't recognize. That even organization says, yes, we are issued this document.
It's
And
not
if
only
you have your own
India.
facilities somewhere, take these people and keep them safely there.
I have to just go through
But
and check it.
again, mind you, that certificate is issued subject to the national laws of the country. So with the help of that certificate, you cannot intrude upon the national laws of another country. These are human problems, actually. Not just claiming rights here and there.
For them, the rights are very limited. Limited only.
I just,
Yes, only limited
What to
rights.
do? Why don't they take the help of the world community and fight against the place from where they are displaced? Why don't you do that? instead of disturbing another country and spoiling their equilibrium. Yes, Mr. Day, something is there. Sir, does the UN have something?
We'll try to get more information on that.
If we have, implement the UN, we'll direct them to take charge of these people.
We'll take instruction, Lordship. We'll just do more research work and then we come.
Otherwise,
to
what to
this.
do? Otherwise, how can you disturb the national laws of another country? And this is not a matter of just a few people.
Yes.
Here, the
Lordship.
petitioners may be 10 or 20.
Yes, Lord.
But moment we pass an order, lakhs of people will follow it. Yes, we are also here.
Because
This
there
is
is a
only,
refugee colony.
this is
in
only
Delhi
a
also.
representative of a huge number of people. Experimental basis. Let's see what kind of relief we get. And moment you get something, a floodgate will come up. How can you control all this? And out of them, if you can almost take judicial notice, quite often we keep seeing in the papers that many of them are the extremist elements also. If you ask the Assam police now, they'll give you the entire statistics. These are very delicate matters. And what material you have regarding persecution in the or a country of origin? Do you have anything other than statements? And a few media reports here and there.
UN reports are there.
How much of persecution? Is it an impossibility to leave? Or these are sporadic incidents at times happening? Are these events persistent enough over a long period of time?
It's persistent for a long
Then-
period of.
If it is so, why don't you take the help of the world community to overcome that problem? Why do, if you, instead of getting a refugee certificate from the UN, why don't you take it up in the UN?
Now, as far as I heard, that International Court of Justice is taking up the refugee issues.
Take it up. So you go and get yourself implemented there also. If the International Court of Justice gives some verdict, definitely Government of India will follow it, if it is applicable to Government of India. But otherwise, I mean, realize one thing, the entire equilibrium will be disturbed.
On this issue, we'll get more clarity
I
from
think
UNHCR.
This much more materials
Yes,
than a few documents here and there being produced on SOPL. Okay, yes, next item, what is it? Oh, Bipul Biswas.
Yes, Lordship, here petitioner number 1, he died. So I will substitute that. I'll file a petition for that because petition, there is no reference against 2 and 3. 2 is the wife, 3 is the son. So son, I'll substitute petitioner
Do
number.
one thing,
Yes, Lordship.
we declare against 2 and 3, there is no reference and no declaration is applicable against them.
Yes,
If
Lordship.
they want, they can make specific reference against 2 and 3. Regarding 1, we close it, but give liberty to the legal heirs of 1 to assail the same order.
Lordship, if it's pending within a week, I'll take only week's time so that I can implead means legal heir as implement petition I'll file and
It
then.
stated that the petitioner number one has died during the pendency of writ petition and there is a requirement to substitute the legal heirs. Adjourn for the purpose,
Fixed time.
2 weeks time.
Yes, Lord.
Adjourn for
Deeply.
2 weeks as paid for the purpose, yes. Yes, next 5.
Net page loss.
Yes, sir.
Lordship, this is.
Ashok, Ashok Ali,
Lordship,
who is the father?
Lordship, page 20, Lordship.
20.
And except 3. Aswaruddin is father.
Asuruddin is the father.
Asatan Nasa is mother.
Asatan is, which document will show Asuruddin is the father?
Lordship. Page 23, a Gupta list of 1985. Lordship.
Village is different,
Village in different version.
so prove the shifting.
Lordship, initially petitioner were village of
Mhm,
Palhati,
sorry.
Lordship.
What happened to the mother Asatan Nessa? Acha, it is there.
Our name was in the.
The
voter list.
petitioner relies on the voters list of 1966 of village Palhazi in the present Borpeta district, which contains the name of Asuruddin, son of Abbas Mia at serial 1115 and claims him to be the father. Petitioner also relies on the voters list of 1985 of village Bolobhita,
Balavita.
which contains the name of Ashok Ali, son of late Asaruddin, as well as Asatun Nessa, wife of Nasruddin. But it is noticed that the voters list are of 2 different villages, meaning thereby that there is a claim of shifting by either by the petitioner or by his father.
Yeah.
Relevant materials may be produced before the court, which may substantiate the shifting
Lordship,
list after 1 week. Next slide.
Lordship,
please.
I'm not, the matter was not finally disposed of, Lordship. This writ petition is against the interim order, Lordship. Pending-
Interim order, what kind
Lordship.
of interim order?
Lordship, petitioner was examined and later on through Gabura was examined from the different villages. And later on, the petitioner filed a petition to call the official witness from the election office and circle office, Lordship. to
What
prove
will you do with them?
Lordship, to prove the certificate.
How can a circle officer prove whether one Asaruddin had shifted or he had not
One
shifted?
Jamabandi copy was exhibited, Lordship.
Sorry.
Lordship.
For Jamabandi copy, you don't have to examine the circle
No,
officer. He is a government officer.
Lordship,
You don't have to examine him.
Lordship, and page 33, Lordship.
It's better we examine it ourselves,
Lordship,
whether you can discharge the burden
Lordship.
to prove that you are a citizen. If you are successful, we'll send it back.
Lordship.
Item 6.
You need to put it in love, man.
Yeah, please, bro. Worship the petitioner, father's name is appear in the voter list of 85 and 79 also, my lord. His grandfather names appear in the voter list of 1965, my lord.
Father, which page?
Father, my lord, page 45. Mugur Ali,
Sorry,
page 45, my lord.
45. Mughal Ali is the father,
Lordship. And grandfather, my lord,
grandfather,
page 36, the NRC, my lord.
page number.
36, my lord.
NRC is not admissible.
65, my lord. Page 38,
Page
38.
38.
Alemakan. Grandfather. And grandfather of the Mozilan Bibi.
Alema Khan is the father,
No, my lord. Grandfather.
grandfather.
Lord.
Mughal is the father.
Father.
Very well. And which document will show
Uh,
that Sukur is the son of Mughal?
Page 51, my lord. Voter list of 2005.
Village is different.
In the my lord, 93 voter list, my lord, it is the name of father is appeared due to erosion of the Bhelagati village, my lord. He shifted to number 3 Bordal. And father name also
The
appeared in,
petitioner may produce any relevant material that Mughal Ali, son of Alem Khan,
which was
whose name appears in the voters list of
93 also, my lord.
1985 of village Bhelakhaiti,
Lordship,
had subsequently shifted to village Bortola.
lordship.
List after a week.
Lordship, the annexer 11, that is Bortola, my lord.
So they're shifting. Shifting is not a matter of only making a statement. Shifting is a matter of proving with necessary material that there was actually a shifting.
And the voter list is there, my lord.
Which voter?
1993 voter list. my lord.
Hmm.
The village Bortola. In the name
How
of,
do you know?
in the name of father, my lord.
The same name Mughar of
Sir.
Bhelakhaiti and the Mughar of Borsola may be two different persons also. How do you know? Unless you prove it.
And the village headman also deposed, my lord.
They continue with the hearing. Okay, but he wants to. You want to continue with the hearing,
Next,
or you want to produce material?
I want to, my lord. After 2 weeks, my lord.
Because without material, we can dismiss the
Lordship.
petition. No difficulty.
No, my lord. Kaubara will
If the Gaumbura has actual knowledge, it will be accepted. But if the Gaumbura only as a Gaumbura makes a statement, no. Find out. Ask Mr. Ali. He'll give you one way how to find it out.
Item 8 for orders.
The last occasion. Lordship, there was a report of.
My lord had indicated the pilot is going to dispose of certain directions of a my lord's order passed in one WPC.
This one,
Yes, PW is done.
B. Davis Larry. There we discussed the entire law of this scheduled tribe and
Yes,
traditional forest
scheduled tribe.
dweller. You apply under that act. If these people, there is a good possibility that they may be traditional forest dwellers also,
Yes.
scheduled tribe forest dwellers.
Well,
Then they'll process your matter. We do not. Heard Mr. B. Burwal and also for the petitioner, Mr. G. Gogoi for the respondents in the forest department, in the government of Assam. Anybody else? Yes. C. Sharma for the Dima Hassan. Northeast, North Kashar Autonomous Council, and NC Hills Autonomous Council. The petitioner's hearing all claim to be inhabitants of the villages Mangadi Hawar, Palai Pahadi, Diung Gyaosa, Kimtao, Diha Kubra 2, Roman 2, Haiplayung Disa, Bilinpur, Hangum by Zora, Masodia, Papunghat, Gorongisim, Mahurba Kurangbra 2, Santipur, Sibbao 2, Rongpang Disa 2, Lucky Bill, itu synopsis of Pabo, Bote kita lagi, heading by both, etc. The petitioners claim that their respective villages were set up several decades ago with permission from the NC Hills Revenue Department. আগতে ভিলেজৰ নাম যে লিখিছো of Dima Hasao district. In the circumstance, this PIL petition is filed with the following prayer. Following prayer to Kutkuta, page 29. A reading of the prayers makes it discernible that the first claim of the petitioner is for a direction to the respondent authorities to recognize their respective villages as revenue villages, in as much as they are located on land which are under occupation of the local scheduled tribe hills community inhabitants. The second prayer is that the aforesaid villages, the respondents be directed that the aforesaid villages be recorded in the revenue records as village to ensure its legal status as a revenue village, and thereafter subject the villagers to the laws relating land, like granting land patta, permanent residence certificate, NOC for their children for education purpose, etc. The third prayer is for a direction to appoint Gaubura for the respective villages by the NC Hills Autonomous Council Revenue Department for effective management of the village administration. A reading of the prayer itself makes it discernible that although the petitioners claim that they are in occupation of the lands concerned for several decades, but their lands are not recognized as revenue villages, nor they are enjoying the benefits as may be entitled to a resident of a revenue village. In order to appreciate the claim of the petitioners, a question had arisen as to whether the lands over which the petitioners are having their occupation are located inside the reserve forests or they are outside reserve forests. Accordingly, upon obtaining necessary information from the Forest Department of the Government of Assam, Mr. D. Gogoi, Land Counsel, representing the department, had made a statement that all the lands which are known by the names indicated above, over which the petitioners are having their occupation, are located inside which reserve forest?
MUBA, MUBA.
MUBA.
MUPA.
MUPA are located within the MUPA reserve forest. Full stop. As the lands of the petitioners are admittedly located within a reserve forest, comma, land revenue regulation comes on. Land revenue.
Well, 23 villages out of 23, 22 falls under the reserve forest. One is excluded.
No, except falls with the reserve forest, comma, except for one village, namely
Sandipur.
Santipur. Full stop. As the claim of the petitioners in this writ petition is for a direction to recognize the villages of the petitioners as revenue villages and further to provide them with all such entitlements as may accompany upon a village being recognized or declared as a revenue village, comma, we also examine we also examine the relevant provisions of the Assam Land and Revenue Regulation 1886, comma, for the purpose. Full stop. The concept of revenue village flows from the provisions of the Assam Land and Revenue Regulation 1886, agote short kori thoi dibo regulation from the regulation of 1886 and the provisions of law and the procedure applicable. Read the last sentence. Applicable in respect of a revenue village are provided in the regulation itself. Accordingly, we examine as to whether the lands under occupation of the petitioners, whether in respect of the lands under occupation of the petitioners, comma, the provisions of the regulation of 1886 would be applicable. Stop. Section 4 of the regulation of 1886 provides as extracted. A reading of the provisions of section 4 of the regulations of 1886 makes it discernible that chapter 2 of the regulation providing for rights over land are applicable to all such land except in respect of any land included in any forest constituted a reserved forest under the law for the time being in force. As the land under occupation of the petitioners are, except for the village Santipur, comma, are included within the Mopang reserve forest, comma, therefore, as per the provisions of section 4 of the regulations of 1886, the provisions of chapter 2 thereof, that is rights over land, comma, would not be applicable in respect of all the aforesaid villages except for the village Santipur. Full stop. Accordingly, in respect of the villagers of village Santipur, we provide that the villagers shall make an application before whom? NC Hills cannot, I think. Is revenue a transfer subject? Or revenue is retained by the government of Assam?
Malad Council.
No. If revenue is a transfer subject, it will be the council.
Council.
If it is not a transfer subject, it will be deputy commissioner. Are you sure? Please check up. No, they are making a party will not make it a transfer subject. Otherwise, our judgment will be wrong. We are keeping it open for the time being. Just check up and tell us whether revenue is a transfer subject or not under the strict schedule. Keep a look. Right. They shall make an application before the blank Thuidiok, whichever is the authority, for declaring the areas within the Hantipur village to be a revenue village. Full stop. Upon such application being made, the blank Thuidiok zone authority shall consider as to whether the said village do satisfy the requirements under the Assam Land and Revenue Regulation 1886, and if yes, to pass appropriate orders declaring the village to be a revenue village. Full stop. If a declaration follows that the village Sandipur follows the village Sandipur to be a revenue village, the inhabitants of the said village shall be provided with all such rights and entitlements as may be available under the Assam under the regulation of 1886, including the rights over land. Full stop. In respect of the villages other than the village Santipur, comma, as, comma, it is an admitted position, comma, that such lands under occupation of petitioners are located within the Mupang Reserve Forest, comma, we are of the view that as the petitioners claim themselves to be indigenous scheduled tribe belonging to the indigenous scheduled tribe hill community, there is a possibility that the provisions of the scheduled tribe area. How is the brown type 254 maybe, page number 254. The indigenous to be belonging in the agor indigenous to kati diok pisot aru ekbar likhisu scheduled tribe hills community of the scheduled tribes and other traditional forest dwellers bracket recognition of forest rights bracket close Act 2006 may be applicable. By our judgment dated 19/5/2020 in WPC 4608/2019, a detailed consideration had been made as to what category of people would be entitled to the benefits under the Act of 2006, short করে তৈরি আগতে, and the procedure to be adopted in recognition of any such rights provided under the said Act in respect of such persons who may be entitled to the benefits under the Act. Full stop. The basic consideration on the applicability of the Act of 2006 would be that the persons who claim the benefit under the said Act must satisfy that they are forest dwelling scheduled tribal as defined in section 2C of the Act of 2006, or that they are other traditional forest dweller, one inverted comma forest dwelling scheduled tribal inverted comma aru other traditional forest dweller inverted, as defined under section 2 bracket O of the said Act. In the circumstance, all such petitioners and any other person who may be inhabitants or occupants of the land of the villages, of the aforementioned villages, other than the village Santipur, comma, which are located within the Mupang Rivers Reserve Forest, comma, may make an application to the, under this Act, who is the authority? Mr. Gogoi, who is the authority under this Act? Will determine that, right? Procedure. May make district level, may make an from, it starts from Gram Sabha. May make an application through the Gram Sabha, may make an application to the concerned Gram Sabhas for initiating a process under section 6 of the Act of 2006. Any such application may be given its reasoned consideration by strictly following the procedure provided in section 6 of the Act and as discussed in more detail in the judgment date aforementioned judgment dated so and so, and thereupon bring the process to its logical end by passing a reason order. If the reason order happens to go in favor of the petitioners, the entitlements under the law, under the Act of 2006 may be provided, and if otherwise, the petitioners be duly communicated of the reasoned decision that may be taken in the aforesaid process. PIL closed with the above observations.
Revenue.
Itu eta by notification. Subjects of for education transfer, transfer, someone not. Regulated transport or not, there is specific notification. Enabling power. There is power. Have you gone through the notification regarding transfer of subjects? We can't follow a verbal instruction without authenticating it.
Lordship, then
Suppose it is wrong, my judgment will be wrong.
Yes, my lord.
As per constitution, only BTR has the
Yes.
revenue of the power lordship.
No, no,
transport.
huh?
But for Karbi Anglong autonomous, there is no.
No,
such.
no, under the sixth schedule, there is a provision that the state authorities will issue a notification by which the various subjects that are transferred to the autonomous council will be notified. So there must be a notification
In fact,
of the government of Assam.
In-
You go through that notification
Lordship.
because education is a transfer subject. We are quite aware. Transport is a transfer subject. Similarly, some more are there also, like handloom, etc. are also transferred.
Lordship, I'll get.
But
confirmed
whether-
on that.
Revenue is transferred or not, we are not sure.
Yes,
in
Just
fact,
find out from that
I should
notification,
get confirmation from the hill areas department, Lordship. They
either
can
from
say.
the hill areas or from the revenue.
Lordship.
If it is transferred, it will be somebody in the council who will take a decision,
Yes, Lord.
the appropriate authority in the revenue department of the NC Hills Council. And if it is not transferred, deputy commissioner.
in fact, I tried, my lord, logging the website of the council, my lord. It doesn't reflect this revenue subject. Other subjects are there, my lord. Which are subject, there's subject.
Okay, others are there, then revenue may not be.
Revenue is not there, my lord. PWD is there, my lord. Panchayat is there, land reforms are there, irrigation is there,
Hmm.
but we don't find revenue, my lord.
Land revenue it is not.
No, my lord. Land reforms are there.
Section 3 of the sixth
No,
schedule, the power.
That is the only an enabling
But it
power.
is collection of.
But there has to be a notification pursuant to that power, which will be the guiding factor.
We'll try to find it from the hill.
Please find out and give the answer to the question. Same order will remain either way.
Lordship.
If it is not transferred DC, if it is transferred,
Lordship, I'll tell it on-
the council.
Yeah.
Item 9 for hearing.
Council power 9 the council whatever is transferred, completely transferred. And if it is not transferred, council does not have any jurisdiction. So it will depend on the notification. No, I have a notification also. Transfer subject. এখানে নির্দিষ্ট আছে সেটা বাকি যেটা বিভাগ।
May please, my lord.
Oh, that one, huh?
My lord.
Did you find any answer? Everything can be done.
This is Criminal Code and Border Security Force Adjustment of Jurisdiction Rule 1969. Just want to know. রেজিস্টারটা মানে বলছে যে আমি আমার বিএসএফ কোড করবো বিচারছি এখন এনে কোর্স বানাই ডেলিভার আছে সাইডে দেখি আমি তার পেজ নাম্বার 25 উত্তর আছে নাকি? উত্তর আছে। আছে একটা।
What order was passed under Rule 9? Suppose we ignore the initial part. First, he has to be produced to the magistrate. Magistrate will give notice to the BSF competent authority. Then BSF competent authority will again notify the magistrate whether the magistrate has to try or
Yes.
but ultimately it leads to Section 9, where a person subject to the act has committed offense, which in the opinion of the competent authority ought to be tried by a magistrate in accordance with civil law. So before, under the rules also, an opinion has to be formed that this particular offense will be tried by the magistrate or by the competent authority or by the authority within the act. Where is that decision, opinion?
Lordship, perhaps.
No, from the records you find out, where is that
Yes,
opinion?
Lordship, I have annex 1, page 193 of my affidavit.
Page
Running
93,
is 193, that is also in the record,
193.
193. That is by which the district and session judge had remanded the matter to the BSF court, Lordship.
They cannot do it.
We have,
No, understand. Running page number 193, running page 9.
25 of my affidavit.
25, 151. Running page ends at 161.
Annex are 8.
No, totally one. Actually, you have running page here.
I have my, in my
Make it on
copy,
your own. Okay.
done that.
On which page?
Page 25.
25. So district and session में दोनों बोलो. Come to that that big paragraph now on receipt of the charge sheet.
Lordship.
On receipt of the charge sheet, the committal magistrate took cognizance and committed case to sessions. The magistrate cannot do it. So this order is also without jury because you see, you come to come to rule 3 of your own rules.
BSF rules, Lordship.
No, this rule you are given today.
Trial of person subject to the act.
Where a person subject to the act is brought before a magistrate and charged with an offense for which he is liable to be tried by the BSF court, such a magistrate shall not proceed to try such person or inquire with a view to his commitment for trial by the Sessions or High Court. The magistrate cannot even commit the matter to the Sessions Court. So now you read that page 25 you are referring. On receipt of the charge sheet, the committed magistrate took cognizance and committed the case to the Sessions. He could not have done it. He did not have the power. This is why the whole thing got misdirected. Otherwise, what would have been done if you read beyond rule 3, say rule 4. Rule 4 is before proceeding under clause 3. That is
Trial of.
that is trial. What the magistrate will do, magistrate shall give written notice to the commandant of the accused until expiry of 3 weeks in case it's located in Nagaland, Assam, etc. 10 days outside this area. He shall not convict or acquit the accused under section 250 over so and so, frame written charge, make an order committing the accused for trial by High Court or Session, transfer the case of inquiry. He cannot do anything. Magistrate, what will he do? He'll issue notice to the commandant of the battalion where the accused is serving. Now read procedure on notice to magistrate. Where within the period mentioned in rule 4 or at any time thereafter before the magistrate has done any act or made any order referred to in that rule, the commandant of the accused or the competent authority gives notice to the magistrate that in the opinion that the accused should be tried by BSF court. The magistrate shall stay the proceeding and if he is in power, this thing. Now, so the BSF authority will take the decision. This also has reference to that rule 9. He will form an opinion whether the BSF court will try him for this criminal offense or the regular criminal court will try. This is the opinion we are asking all along since last date to find out from the record. But this opinion will not be there because this procedure was not followed. What this magistrate has done, instead of issuing notice to the commandant, requiring him to take a decision whether BSF court will try or the regular court will try, he had already committed the matter to the session judge. And what the session judge has done, the trial could not proceed yet as editor of posted so-and-so district, so-and-so, what claim we tried. After taking over the case, court perused the case record, came to the notice that the application was submitted to the district magistrate for claiming to try the case by BSF. On detection of wrong court, representative of BSF was advised to present fresh application addressing to the proper court as district and session judge. District and session judge cannot take this decision. It is only the commandant who will take this decision and he will form an opinion. Opinion means he will give his reasons why this man will be tried by BSF court or why he or whether he should go to tried by the regular court.
Lordship, the next para, small one, the applicant pray to the court to refer the case to BSF court to try the accused.
Yes. Mr. Bhukan, you subjected yourself to their jurisdiction.
My lord, one provision I have seen in CRPC, that is 475, where it says, my lord, delivery to commanding officer of a person's liable to be tried by the court martial.
So they must have followed 475, then handed over him
Yes,
to the
Next
BSF.
page is there.
But you have on your own volition, you said that I want to go for BSF court. So we don't go into that issue.
Lord sir.
Now the next complicated situation comes. If we don't go into that issue, we deal with this petition as a writ petition or we deal it as a criminal appeal. Which one to follow?
Lordship, so far Lordship, although it is of, I have a judgment that is.
This
related-
entire thing had happened, Mr. Phukan, because firstly, there is a deviation by the magistrate. Secondly, there is a deviation by the sessions court. Thirdly, you on your own had opted to go for the BSF court.
My lord,
Maybe thinking that BSF court will be more sympathetic and something at that time, some thought may have come to this man.
the record person again, application, no, sir.
No,
I mean, because-
the applicant pray to the court. That must be an oral prayer.
Yes,
And it's
it is in the order.
it's a judicially recorded.
My lord.
We have to accept it to be right.
Next page to show. 126.
And public prosecutor submitted that prosecution has no objection if it is tried by BSF.
Now,
The registry shall furnish requisite document under 375. Very well.
the applicant representative.
As well as Rana Devi appears the person of the case where.
It puts the applicant may, the applicant pay to the court to refer the case BSF.
What is the judgment referred?
Lordship, this is,
It's applicant.
this is Army Act, but here Lordship, whether it should be treated as a.
Let us say,
Yes, Lordship.
scope of court martial proceeding are held subject to judicial review under not 227. Right.
Para 22 and.
There are
23.
22.
22,
If
mainly
the applicant
23,
was
Lordship.
My lord, may I pray, my lord? One more thing, this applicant here shows what the applicant prays. Applicant means my lord BSF, not me.
Yeah, applicant is BSF, but they had,
Oh, sir, not you.
Yes, this applicant is BSF.
Then the audio prayer will not do. Maybe he's right. We have to call for the records of this case then. Who is
Yes,
the applicant? Learned assistant PP so and so appeared for the state on behalf of some impulse in connection in the instant case based on the FIR law.
press application, Lordship. Previously we filed application, they requested us.
Understand, but it is your case. I want to try. But where is your opinion? You cannot say make that claim without an opinion. One way out is, as there is a procedural aberration,
Lordship.
we set aside the conviction and the trial, ask you to go from the stage of that magistrate.
Lordship, may I read the whole order, Lordship? So Lordship, the applicant pray to the court to refer the case to BSF court to try the accused under BSF Act and rule. The learned APP submitted that the prosecution has no objection.
So what about his right?
His right is, his representative is also there, Lordship.
Maybe.
Next para.
Maybe that will not a concession by default. That is not applicable.
Applicant representative as well as the learned APP peruse the
Because-
application.
If the BSF forms their opinion that we will try it, BSF court will try, not the regular criminal court, then we will be putting one question to you. At the time of forming the opinion, did you have the competence to adjudicate a 302 trial? The person who would be presiding that proceeding, does he have the basic qualification and expertise to conduct a trial under 302? We would have put that question. But as that situation has not come, we cannot put you that question. And it is mandatory, mind you, these are mandatory rules that BSF has to form an opinion that it will be the BSF court will try or it is the Court of Sessions. And there is a purpose behind this rule. Purpose is, depending on the criminal offense that is alleged, you take a call whether you have the competence to try it or not. Because mind you, this is applicable for all kinds of offenses, from the simple petty offense to that of 302, everything is included.
Yes, Lordship.
Then we'll ask the presiding officer, now you show your credentials that you have the complete competence to make a 302 trial.
Here, Lordship, rule says competent authority means Director General, Inspector General, or Deputy Inspector General of the BSF.
Whosoever it is, where is your opinion?
Opinion, I have to find it from the record. Might be there, Lord.
Let us see your opinion. What are the reasons accompanying the opinion? We'll see. If the reason is bad, we'll set aside that opinion itself. Madam Sharma, you please keep it in one mind. Even when the High Court appoints amicus for 302 cases, there is a requirement of 10 years experience as a lawyer dealing in criminal matters. Okay. Cases of a particular nature, only senior advocates can be appointed as amicus. We have those rules. Why are these rules framed? Because 302 is a very, very serious affair. It's quite a complicated law. It is not only that one man kills another man. You will not only have to determine whether X killed Y or not. If X had killed, 302. It's nothing like that. Various stages, various circumstances are involved. So to develop that competence, the High Court requires 10 years of experience for being an amicus. The High Court requires for some matters, it must be only senior advocates, designated senior advocates. This extra precaution is taken. Who can try a 302? Only a session judge. And who is a session judge? He is a grade 1 officer, having experience of at least a given number of years in dealing with it. His Lordship can know the details about it. Now, if this is the requirement of law to try a 302, one commandant or one additional director somewhere from the BSF, if he tries and that some authority forms an opinion that we will try, we will like to have the reasons why that opinion will form. And we'd also like to know from you whether that man had the competence to try a 302. For the other part, we are not concerned. You dismiss a man under court martial, we are not concerned with that. That is your call. And that will be looked separately. Now, if this reasoned opinion is not there, that the competence of the person had not even gone into, that means without determining the competence of the presiding officer to try a 302, a man has been tried. His right is violated. And mind you, one leads to dismissal from service. It's another factor. Other one leads to conviction and imprisonment, that was a life imprisonment. Suppose the circumstance would have been more grave, he can also give death penalty. Can one BSF officer give death penalty to a possible convict? Can you conceive of that situation? Unless the presiding officer is shown to be equally qualified that of a session judge. He has that competence. So that we can draw an equivalence between the two. And unless that has happened, we cannot allow a conviction. Merely because the BSF rules provides, yes, a discretion is vested. And again, under the law, what is a discretion? Discretion is always based on reason and reason on the basis of law and the circumstance.
Of course, Lordship, Bhagat Lordship.
We will examine that aspect.
May I submit that, Lordship, that is not the stand taken by the accused person, Lordship, during that he could have challenged.
That stand did not be taken.
Lordship, first I have to
Madam
say-
Sharma, we are not in a civil suit. We are in a much more serious proceeding. beyond civil suit.
In fact, Lordship on the last occasion asked Mr. If Mr. R.K. Dev Chaudhary is present, he is on lake, so let.
So if you want Mr. Chaudhary to represent, he is welcome.
Yes,
It
Lord.
doesn't matter.
And
for-
I also have to go through whether
But
there is the
these
opinion.
are serious questions which will have to be answered. Not otherwise.
Lordship. I will verify whether the opinion is.
Because
from-
if I allow this, if I dismiss this petition, we'll be accepting the law that any officer of the BSF, by being appointed as a presiding officer, can decide a 302 matter also. And he can also give a death sentence in a case if he wants.
Who can decide that is mentioned in the act? The Director General, the Inspector General, Deputy Inspector General. Only that.
We have gone a little beyond what you were submitting. We know it is mentioned. We are on the word discretion. I think section 80, yeah?
My lord, yes.
80. Read section 80, there's a word discretion. And find out what is the legal purport and meaning of the expression discretion. What are the requirements of a discretion? You have it. Having a power and exercising a power are two different aspects. Instead of the word, had it been mandatory, then we understand that it is only this man who will decide it. So please answer the most serious questions that have arisen rather than trying to find a way out here and there.
Instruction was that.
Otherwise, why does the law provide so many protections to a possible accused when he's being subjected to a trial of the serious offenses like 302, etc.? Why? The regular courts also could have been anybody can try. Lawyer, anybody can appear. Amicus, anybody, it doesn't matter, no holds barred. It's a discretion of the authority to who will do it. Why are these protections being incorporated? And if we read the order, I'm quite sure the intricacies of the law of 302 had not been gone into. Only thing that may have been determined is that this man had killed the other person. That's all. Sometimes 302 killing is converted to 325 also, or 323 also. 304 is always there, part 1 and part 2, but sometimes it is reduced to that extent also. Why? Because of the circumstance and the law applicable in that circumstance. Who had gone into these questions? It's not a very easy thing to do. And we don't expect a regular officer to be so well versed in the intricacies of law. It's not expected also of that man. Ask Mr. Chaudhary if he's available. Or else, from the records, we want this question, and first we go to this question, then we will go further ahead. I will. Otherwise, is it?
Itu আছে extract to দিছি আমি এটু আছে extract of 41 42 BS
We'll assemble at 2.
Lordship.
No, Sharma, whenever it is a case under the Army, under the Army Act, court martial, you have a department called JAG, Judge Advocate General.
Yes,
Somebody may be available in that department who may be having the equivalence or competence of a sessions court judge.
yes,
You may be having
yes, yes. We
your
have it.
experience,
Yes.
your knowledge, your competence. Suppose a 302 in an army, that may be possibly be saved if the discretion is used that either the presiding officer or a member of that court martial will be one of these person having qualification of a session judge. And they can also conduct a trial. That is one way of saving it. But BSF does not have this kind of a department.
Judge,
They may have a legal law officer at the best,
but other department have, so perhaps BSF also have.
fully competent.
Judge Advocate General is there in SSB and all others, so perhaps BSF also have.
No, but are these people having equivalence of that of a sessions court judge?
Equivalence in which one?
You
Lordship?
need the equivalence because otherwise, why don't we allow a magistrate to decide a 302?
They are LLB, and apart from
No,
that,
LLB, you'll find every nook and corner, you'll find LLBs there. He may not be an advocate, also a lot of LLBs are there. But LLB is not only the criteria.
but Lordship, may I submit one thing here? He had use his discretionary power under
Section
because
80.
writ petition, W
Section
is,
80, discretion.
yes, Lordship.
Madam Sharma, we are indicating you obtained number of times till now. Discretion is doesn't mean without any basis.
Here, this punishment is on the basis of his service also, Lordship, not only.
You have to segregate the service aspect. Service aspect, you deal in any manner you feel like. We are not on that. Regarding his service condition, you place him before whichever court you want. We are not on that.
And in this petition, their main prayer is that
Madam
to shift.
Sharma, why are you not responding to the genuine questions you are only trying to force it upon us.
In fact, I have
That will
informed,
not help you. We are putting a very serious question. You will curtail the life and liberty of a person who will be adjudicated by a person who may not be competent to do that. It's a question under Article 21 of the Constitution. Forget about your Army Act and BSF Act and all. Sentencing a conviction and sentencing a person for life is you are affecting the life and liberty of that person. And if the authority deciding it is not competent to decide that issue by virtue of his qualification, eligibility, and capability, will Article 21 not be violated? Think a little larger, not within the within the narrow periscope of this one section 80 or by discretion and all. And two, what is discretion under the law? If the law gives an authority a discretion, does it mean he can do anything he feel like? Yes, I decide this one. But according to me, it will be X or it will be Y. No. The discretion has to be based on reasons and material and also taking note of the attending law and the requirement of the law. That is what is called exercising a discretion.
In fact, I have informed Mr. Architect today, but in Sumoto PIL.
It's okay, if it's not available, if you
He
want
will
Mr.
come
Chaudhary
down.
address, we'll accommodate you for that purpose. But that doesn't mean you just brush aside everything and then say, no, everything is all right. Why section 80? And it will have some impact in many other matters also, if we decide whichever way we decide. We need some more serious presentations from the respondents. Also, so is there any judgment of the Supreme Court or any other court on this issue?
No, sir.
Have we come across?
No, madam.
Then the issue is open. We have to decide it. If it is already decided, please produce the law, we'll follow it.
I have not checked that, so I am not aware
Please
whether
do. We
there is
requested you
case.
last occasion itself. Why didn't you check it?
Because this,
Sorry, don't give all these
This-
unacceptable answers. Please don't give it. We put this question on the last occasion when we requested you to check it, that if there is already a determined question has been determined, please produce before us. And today you are saying, I have not checked up. Not accepted. What we have checked up? Have you,
No, my lord, I have.
you
tried
have
checking.
checked up, you did not
No,
come
madam.
across.
Regarding competency, my lord, I have not.
In this case itself, I think there are materials that this person sought to give a clarification under what circumstance he had caused this act. So somebody will also have to make a determination whether that circumstance makes it a culpable homicide amounting to murder or not amounting to murder, or whether if it is not amounting to murder, whether it will be 304 part 2 or it will be 304 part 1. These issues are not gone into. Only 2 issues are gone. Yes, I exercise my discretion. X will be the presiding officer in this force court. And the presiding officer takes a decision. Yes, material show this accused has killed the other person. Fine. 302, life conviction. This is not how matters have to be decided. So therefore, the relevance of questioning the competence is even more in the context of this case. If I understood a little beyond your perceptions, you have to answer.
May I? In BSF, as your lordship wanted to know, in BSF, what they done, your lordship, if some incident took place, they appoint one commandant rank officer. He inquired, he collect evidences also. After collection of evidences, they appoint GSFC. This is, my lord, General Security Force Court.
But
It
this is what
consists-
has been
It
done.
consists one DIG level officer and other 4 commandant level officer. They even adjudicate 302 what.
This is what we are asking. Does the DIG has the competence of deciding a 302 matter? And we are also ready to segregate the service conditions of the person who is dismissed and conviction under 302. Service condition, you decide. There's no difficulty in accepting that. What about 302?
They are
And mind
exercising
you,
judicial.
consequence of a conviction under 302 is life imprisonment. Given case, it may be death penalty also. So you are impacting the right of the right of life and liberty.
5%.
So we have to look at from Article 21 point of view, whether the manner in which he had done is strictly as per law, and whether the accused was given an adequate and appropriate opportunity of hearing by a competent authority.
In fact, my lord, so far I appeared in one of commission of inquiry, your lordship, before my lord, that judge. And my lord, some objections were raised by me at the time of argument. And
Refused.
and they decided in one line overruled.
Understand, because that man doesn't even know what he is deciding.
Only one line. And
This
they
is the-
conduct, my lord, this
Understand,
proceeding in 5 days
See,
continuously.
the commanding a force and deciding a sensitive legal issue are two different aspects. When you are commanding a force, when the forces are in furtherance of their regular duties, is another matter. One word is good enough. Attack is attack. Don't ask any question also. Same approach cannot be made to a
Yeah, same approach,
sensitive
your
legal
lordship.
proceeding.
In fact, what they did, my lord, they continue with the proceeding regularly, 5 days, 7 days, and they conclude that.
You can do it on a,
My lord, there is no opportunity to challenge if some order is passed during the proceeding, like maintainability or something has been raised. And in one word, it is, my lord, decided overruled. Where the person will go, my lord? Because there is no
so
time.
therefore we are saying we require some more serious arguments from your side to justify it. And it may have impact in many other cases also, whichever way we decide.
They are, so far as that advocate, what is called?
Just.
Advocate judge, he is having that law degree, but so far as panel is concerned,
No, Mr. Goel, degree is not sufficient. That's why you say number of law degree holders you'll find across many different professions, many different occupations, many different places. But that is not enough.
that is required. In fact, I, at that relevant point of time, I was also thinking,
So
what type of judicial
So
proceeding?
therefore we are referring that when we appoint even amicus curiae for a 302 matter, extra care is taken. The rules provide he must be a person of 10 years experience. Why? Even for appointing a lawyer.
Absolutely.
Serious matters, senior advocates alone. This is the High Court rules.
This is going on.
And now the matter will be decided by a person who is not even aware of the legal requirements. And for Article 21, there cannot be difference between a man in a BSF and a other person who is otherwise accused of a offense under 302. You can say one, you know. 302 is that procedure is same for all. For service part, again different, because
That is all right.
forces are a disciplined force, so your principles will be different. You may not retain a person, dismiss him for reasons which may not be applicable for a civilian post. We understand that.
Convicting someone
Different
for life
aspect.
imprisonment and
But what about conviction? Okay, tomorrow, ask Mr. Arpit.
You will come, lordship.
Tomorrow is.
Okay, if he comes today before we rise, we'll hear,
Lordship.
otherwise tomorrow.
Time being item 7.
Last order is.
Lordship has directed the CID to make an inquiry. And they have made the inquiry and submitted a report. Right? Along with the statement of the Gaubura statement is also there.
What is the population of this village? He says that he has issued 30,858
Yes.
certificates.
Yes.
What is the population of this village? That is not
For
stated.
the, in the honorable court order
Okay.
dated 13th of March.
Just a minute. There are 6,925 household of Bhakatgaon and Nomari.
Lodged.
So if there are 6,000 household,
Hmm.
who are the 30,000 people here issued certificate? And that too within a very short period of time.
But, he served as Gaumura from 91 to 2022.
Understand?
And
From 91 to 2022. That means 20, almost 30 years. Law presumes one generation to be 25 years. So even if you say it is 30 years, he must have issued to only one generation.
Sure.
If there are 6,000 households in the two villages, who are the 30,000 people to whom he issued the certificates?
But, now the registers are already available. 11 registered they have seen.
Mr. Nath, in fact, the question we asked to make the inquiry was because of the register. And the inquiry report generally states what is there in the register. We have also seen what is there in the register. We don't need an inquiry report. Inquiry report is asked for to whom and under what circumstance.
But the possibly the voice is not coming. Hello, sir. Hello.
We are also aware that after seeing the register, in what manner it was done. From 1 to 500, again another 1 to 500, from 1 to 500. We have seen that. We not asked you to make an inquiry as to whether that exists or not. It's already taken note of.
True.
The purpose of the inquiry is if there are 6,000 total number of households, who are the 30,000 people to whom this Gaumura issued certificates?
Lordship. This aspect, I'll.
This is what we are trying to look into
Lordship.
or need the inquiry about.
No, my lord.
Peruse the inquiry report submitted by Inspector Popullo Saikia, CID Assam, dated 11/4/2023. The report of the inquiry is inadequate in as much as the contents of the report is already known to the court, and the inquiry was ordered to understand the circumstance under which 30,000, more than 30,000 certificates were issued by the particular Gambura, when the total number of households in the two villages is, comma, as stated in the report, comma, is 6925. A more appropriate inquiry be conducted and the report be submitted. List after 2 weeks. Either he will say that on the average, every household is having 5 members. I have given certificate to each and every member of my village. And that is also most improbable. Or he says, I issue certificates for 4 purposes. So if it is for 4 purposes, I have issued 4 certificates to each person.
To each person.
Purpose wise. Then also it is 28,000 or 27,000. It is not 30,000.
True. True, my lord. That's
And he says certificates are issued for residential,
Lordship.
for opening bank account, family identity certificate to married women who got married. Both are very fair proposition. A woman from his village gets married in another village. He will have that knowledge. He can issue the certificate that X is a woman of my village got married.
Yes, ma'am.
Certificate of proof and death and birth, that is also very fine with a Gambura. He can always do it.
Lordship.
Inheritance certificate. But he is issuing now certificates, so and so is the son of so and so. So where is he having this information? And that too, son of so and so of some other village. Now, when one Gambura is issuing certificates of this nature, naturally people from all around the place will flock to him. You get one such certificate.
From that government. Even if he doesn't belong to that.
If he doesn't know anything, X is the son of Y. I am here to give you a certificate. So everybody flocks to him. Therefore, the number of certificate issues is much, much more. And this is, mind you, only one registered book. I don't know how many more registered books are there with this Gambura.
No, this is serial number 11, serial number 5, my lord, second page, 11, he has 11 registers.
Okay.
Lordship.
Copy of the report. Itu beda ke tu. Beda kata file tu. Case number and keep it. Case number When we noticed what is stated in the inquiry report,
Yes, sir.
we asked you to make an inquiry to whom these certificates are
Very
issued.
True, my lord.
But the inquiry report is reiterating what we saw earlier. We don't need that information.
True, my lord.
You are already aware. Only new information is he maintained 11 registers.
Whether these persons to whom the certificates are given,
Hmm.
they are from that village or from outside.
Or who are they? It
Who are they?
cannot be, because you have issued far too many number of certificates than the number of people you have.
True, my lord. They will look into it. We'll look into it. Lordship.
Otherwise, there must be some systems are being put in place where you can procure and manufacture certificates. And those certificates are now being relied upon in these proceedings. That is the inference you can draw.
Now, if that is happening, that will not come in the account of the Gambura. This Gambura says that
Message goes that ex-Gambura of so-and-so village is there to readily issue certificate.
certificate.
Go to him. This is what is a system is put in place.
Maybe.
In other words, this itself is a system that is put in place.
True.
Please look into it.
Lordship may,
We required a wholesome inquiry. That's
Mal-
why you requested the CID.
Malam. Lordship. Lordship may keep it after
After 2 weeks,
30th May.
30. I think it is. Lordship. Lordship. Okay.
yes, Mr. Arcadi.
Item 9.
Madam Sharma gone. Where is Madam Sharma gone? Has she told you?
She has told me, Lordship, and in fact, Lordship's query, Lordship, I have noted,
Ah,
although Lordship, I would fairly submit, although it may be treated as a core, but what kind of people are
That's what
taking
we
up?
say.
That is-
No,
that is-
we are not on the enablement under the law.
Lordship.
We are on 302 is a very serious allegation. It's a very
Some level of competence.
proceedings
is
of a
necessary,
very high level of competence.
Lordship, that is, of course, Lordship,
CRPC says only session judge. Why magistrate is not given that power?
Lordship, I understand.
When we appoint amicus for attending lawyers for criminal appeal, minimum 10 years.
Lordship,
Serious cases, only senior advocates.
Lordship.
Why these precautions are taken? Because
I
it's a very complicated and intricate law.
have seen, Lordship, that this act and rules, they do
They're
not lay
silent.
down the competence of the officers.
No, they're silent.
who are-
Once they're
that
silent, we
is-
can go
that
into
is
that
what I-
question to fill up the gap. Till the legislature enacts the law on
Yes,
that
yes,
issue.
yes. That Lordship, perhaps I need to take it up, like, I do not know what is the framework right now, but
Please
the
go into it.
Lordship
We'll-
has raised a pertinent issue, even first look that has struck me, Lordship. There
No,
may
one
be a
reason
power-
is there, this person takes a defense that he was teased and provoked and
I've got
all
it.
kind of acts by the others. He had done it. And what the force court has done is, they arrived at a fact that this man had killed the other person. 302. Then 302 is what? Culpable homicide amounting to murder. What is culpable homicide? One person killing another person.
Flush,
And there is also a concept culpable homicide not amounting to murder,
flush.
although it may be a culpable homicide. Who had gone into this question?
There has to be some distinction that it
Huh.
needs some,
And this
Some
question
level of
can be gone
competence.
only when it is being conducted by a competent person.
I have got your Lordship on that. In fact, yesterday when it was given to me, first thing I looked into that. Because it has to be like whether it is a qualified person to,
Definitely. And we examined it from point of view Article 21.
Lordship.
The Article 21,
Lordship,
the life and liberty of a person is curtailed
Lordship,
when you convict and sentence.
Lordship.
So if this is not done by, I don't use the word, or by a competent person, I don't use the word authority,
Lordship,
21 will be violated.
Lordship.
Therefore, if you notice section 80 of the BSF Act, the
Lordship.
discretion is given.
Yes, Lordship.
And discretion, you are
Choice.
well versed with the law based on reasons.
Yes, Lordship.
Reasons that should be supported by material and by the relevant provision of law. That is discretion.
Lordship.
So at that stage, the discretion could have been exercised. That do I have a person competent enough to try a 302? If I have, specifically allot that person,
Yes.
not in general like any other force code. If I don't have, next option, the rules itself says that he can send it to the regular criminal court.
Lordship.
For the service condition part, you retain it for yourself. You decided.
This is
That we are
major
not
punishment.
that we are not questioning.
This is a major punishment. Lordship.
Major punishment, dismiss you do. That's a totally different aspect.
On the criminal side. Life 10 years and more.
Next question is, suppose the circumstance would have been such that for death sentence. Does the force code has the power to give death sentence?
The power is there.
Death sentence also,
Yes, power
it is
there.
there.
It's
So
there.
who will give this death sentence?
That is what. That is what.
Mhm.
So some level of,
I think some introspection is required,
Lordship, I definitely.
protecting everybody's right. from
Yes,
all
yes,
this.
yes. It cannot be simply anyone passing an order.
And 302 cases are not very common also, I think, in the forces.
My lord, yes.
Recently, one happened. I think in somewhere in Punjab or Haryana somewhere. One. But it's not as common as the regular court
My lord,
martial or
yes.
the force
My
court.
lord, yes.
These punishments, Lordship, section 48. In
Hmm.
fact, the worst punishment is death.
That is also there.
Death is also included.
We are not very,
Imprison, then second is imprisonment, which may be for the term of life. So second one,
the BSF Act,
yes, Lordship.
the section we appreciate. But
But who is exercising that? I
it
understand.
has to be somebody who is competent and qualified and eligible to
Yes, yes, yes.
determine that.
There cannot be any question on that, Lordship.
And just because they're member of the force, a different law is not applicable in respect of this. I think the. Hmm. Are we challenging the dismissal from service also?
My lord, yes, because my lord, we have challenging my lord, this sentence.
Are you also
Because, my lord,
challenging the dismissal from service?
My lord, here what happened, we are challenging the sentence. Yes, sentence my lord to suffer imprisonment for life and to dismiss from the service, my lord. He has convicted.
No, you can separate that.
Yes, my lord. That's why,
That
my lord.
that N word can
Yes.
easily brought into play and separated.
If my lord sentence goes, then my lord, that part also goes, my lord. The conviction is.
Mr. Phukan, you are an experienced public prosecutor.
My,
You know,
I understood, my lord.
sentences can also be segregated.
my lord,
Same thing we can do here also.
my lord, lords, lords,
It's not that one goes, the entire thing goes.
my lord. Can segregate it, my lord.
So on the competency of the person who had passed these orders, there also we can segregate between the two.
My lord,
Competency as regards 302 and competency as regards the service condition
My lord.
leading to dismissal. That also we can
Lords.
separate. For the service condition part, he is competent.
That any, Lordship.
That is competent. It
Officer
has to be
can
looked from a different point of view, whether
lord.
there is any procedural aberration in arriving at the decision. 302, maybe we can segregate and say it is the person is not competent.
That has to be
I think,
Yes.
and what Mr. Phukon says that he looked into it, this issue has not been decided anywhere. What Mr.
I have searched it, my lord.
Hmm.
Regarding competency,
Specifically from this point of view.
army is, my lord, is there, but in BSF, my lord, in paramilitary force, I have not find it.
No, no, see from army point of view also, same principle is applicable. Principle will be same. Although the governing statute may be different, principle will be same. Take up from the army point of view also.
I'll have to check up whether they have, Lordship knows,
Hmm.
judge, advocate generals and all those. So what is the level of competency?
Hmm.
I do not know. I'll have to check up on this.
Competency can be determined only upon an prior experience in working in that one,
Yes, that is.
not by your degree
Yes,
qualification.
No, no, not by the way.
Hmm. How many such cases he had dealt in what position?
Not sure.
But there may be situations that within the force, 1 or 2 persons may be competent person.
That may be. So who
In
was
that-
presiding over?
In that case, specifically interest that person.
Yes. So that is what I wanted. Maybe there are competent persons, but who was presiding over?
Who will
Yes.
be eligible to
Yes.
preside over this kind of
Yes.
proceedings?
That has to be looked at.
Now we'll give a much broader and deeper hearing on the. entire
Lordship.
issue.
Lordship.
Right.
তেনেকুৱা কিবা আপোনালোকৰ হেৰি থাকিব চাগে,
থাকিব এইটো এটা চালেহে বুজিব। এনে officer-
standing order থাকিব, standing order থাকিব।
When do we list?
Lordship, you give me 2 weeks time. In the meantime, I'll
And I
Yes, sir.
decided, list for sorry, hearing. Sorry.
No.
Sorry. Already, yes, list for further hearings. You also have to prepare on one more aspect. Suppose we come to a conclusion that this authority was not competent. What will be the consequential order?
It has to be remanded back to the appropriate.
This
competent
person had already undergone for 10 years by now.
You know,
Oh, not for last 10 years.
So if we decide that it was without jurisdiction,
Lordship, yes,
everything goes,
yes.
but the 10 years of imprisonment will remain. That cannot be taken out of the life of this man.
That cannot be accepted.
So now if there is a fresh trial, say maybe go to the sessions court, he'll be convicted once again and one more life sentence.
This period will be set off. This period will be set off.
It has to be set off. And the other issue, what is also going on in mind as we are already going into it. This is a writ petition. 226. Judicial review. 226 is a judicial review basically.
That would have been a criminal appeal.
That's what we are asking.
It struck me.
Just
yesterday.
because it happened to be a court martial or this post court proceeding, we are in a writ proceeding. We'll look into only the procedural aspect, and procedural possibly everything is right. We dismiss the petition.
This struck me yesterday.
Ah.
Lordship. We thought-
But the regular 302 conviction, it's an appeal.
It's an
It's
appeal.
almost a statute, it's a statutory appeal. Appellate court looks it from a totally different point of view. Can a writ court of 226, under 226, when deciding a court martial, which also involves a conviction under 302, we exercise our jurisdiction as an appellate court in a sitting as a criminal court, criminal appeal court, or we exercise our jurisdiction as a 226 court.
That. But I believe it has to be a criminal appeal since
How can we do it?
that is what. Because.
Because
it's merged-
226 is
it's merged together.
already circumscribed.
It's merged together, but since
There
there
are a
is a
number of
sentence.
decisions. 226, the court will not sit as a court of appeal. There are
226
decisions.
is-
and there is no exception method to that.
May not come. I would say a criminal appeal, since it is a conviction and sentence.
So then this petition ought to have been a criminal appeal then.
I would have gone by that.
I think you filed criminal appeal, not this case.
No.
In another case, somebody filed criminal case. It came to the writ side. Not in this case, in another matter of almost similar nature.
But the question lies, Lordship, conviction, sentence, man is inside, is sentenced to 10 years or more. And that too for an offense under the IPC. It ought to be, Lordship, made.
There are books available in more than 1 or 2 volumes. It deals only on section 302 itself. So see the magnitude of the legal principles of 302.
Lordship. But it crossed my mind, Lordship, like whether it would be a appeal or a.
Some, I don't know, some questions are coming to the mind. But the entire thing could have been saved had the discretion being used at that stage. Send it to the regular criminal court and segregate the service condition part, retain it for this force court.
That could have been done.
Then would have solved this second question also. Then he would have got in appeal if convicted.
And Lordship, the civil courts, I mean the criminal courts, while giving it to the force.
The BSF Act, but I know someone refers the criminal court as civil court. Because BSF feels we are the force court and those are the civil courts.
It's a normal term being used. But in another case, Lordship, when my Lord Justice Fukan is telling I had appeared, there, although an application was made by the army to take it to the army, that was refused. And
Sent to the regular criminal court.
it's continuing with that.
Here also one procedure was not followed. We have gone through it, but Manu Sharma is saying.
Lordship.
Rules say it will first go to the magistrate on the 302 part. Magistrate will issue notice to that commanding officer or that competent authority. Competent authority will again issue a notice back to the magistrate. Till this process is done, magistrate is not going forward in this one. Neither he'll make a committal to the Court of Sessions also. Ultimately, Rule 9 says the competent authority will form an opinion whether he will try or dare. There, at the stage of forming the opinion, the entire basis will come. Why he has formed that opinion that it will be done by
Yes.
the force court.
Yes.
All these answers would have been answered at that stage. But here is a case, these rules were also given a go by. Magistrate on its own commits to the Court of Session without issuing notice to the competent authority. Court of Sessions, when the proceedings are going on, one expression is the applicant makes a statement that let it be tried before the BSF court. An applicant, I thought initially it was the accused, but it was pointed out that applicant means the BSF authorities.
They made an application.
They made a prayer, let us try instead of going into all this. PP did not object. PP is for the state. Accused is nowhere in the picture. So Sessions Court sent it to the
He
BSF.
should have also been put on notice.
He was present, but
The formality.
must have been. Don't come in between. So these are the background, you please look into it.
Lordship, I'll try to
Sharma,
get
you also
the
look into it.
framework, how it has been done, Lordship, and what is the level of competence there? And Lordship has indicated this satisfaction
Discretion is,
Yes.
that's a
We'll try to get
concept of its own, how discretion is to be exercised.
Yes, Lordship. I'll try to get that. Lordship.
And also Article 21. Article 21.
Yes.
Although the statutory provisions may give some
That is
enabling
always-
power here and there,
That is all.
that also has to be taken note of.
In fact, this is the first time I'm dealing with so many this armed forces cases. This is the first time I have come across somebody being
Across?
convicted like this. But Worship, there are cases where that penalty has also been given, of course, in the army. I have not been lucky enough to get into all those.
Hmm. But perhaps no one raised the issue, it was not decided also. If Mr. Phokan is right, saying that this issue is not decided anywhere, not gone into. Or is there any law that once you are a member of a force, the constitution as well as the laws will be applied in a different manner? Is there any such proposition?
Worship, that is why the discretion is given in 80.
What have you over?
Yes.
Say, for remaining absent without any cause. Mr. Chaudhary,
Worship.
for remaining absent without any cause. When a person is a civilian employee, the law is little different. When it is the forces, it is again different. Discipline force, that particular judgment is there. Is there any similar provision as regards this kind of issues that members of the force can be subjected to a different law and procedure? Repeatedly.
I'll look into it, Lordship. Section 18.
Exul. Exul. My land.
Or you want it earlier?
Yes. First day.
No, do you want it earlier?
No, my land, it's okay, fine.
Worship, earlier, a few days I will be out of station, Worship, 24, from 24.
First.
In meantime, I am also research on that, but my land, see, look into it.
Some things are very difficult to
Why like this?
follow also. We'll hear in detail. Both.
Item 10,
Okay.
Item number?
Father of the petitioner's name is Amezuddin Mandal Mala.
item 10.
Yes.
Page 22 is the voter list of 1965. Now, while the name is Amezuddin Mandal, but mentioned as Alim Mandal at serial number 57,
Alim Mondal,
my lord. He is Azimuddin Mandal.
sorry.
He is Amezuddin Mandal, my lord. Father's name. Similarly, it was
Where
subsequent.
is the name of Abeduddin?
In the year 1997 voter list, my lord. My lord, page 28.
No, how come Alim become Abeduddin in
My-
1997? It's a lost cause, that's why I say there's a
My lord.
difference between making a claim and
My lord.
substantiate. You substantiate that both are the same person.
Now, my lord. Our elder
The
brother,
petitioner claims that Alim Mondal of the 1965 voters list of village Bhaguriguri. What is this? Patha.
Baguriguri Pathar, my.
Okay. And Amezuddin Mondal of the 1997 voters list of village Unmeguri are one and the same person. List next week on so and so, and the petitioner may produce relevant material which may show that Alim Mondal and Amezuddin Mondal are one and the same person.
All right.
11,
সোনকালে দিব, next week. Yes. None appears for the petitioner when the matter is called. List again on so and so. On further non-appearance, appropriate order shall follow.
item 12,
My lord, in this case, the tribunal has wrongly termed him as a foreigner. Because all the materials he found in favor of the petitioner, my lord, later on said that since he could not prove, since he stated that in 66 he was not a voter. Here I stated, my lord, he was a minor, so he could not vote. Because during that period, 21 is the voting age.
Where is that conclusion that all the voters, all the documents are accepted?
Paragraph, my lord, from paragraph 13 at page
13
23.
deposition all are corroborated with each other, and I found nothing to disbelieve that both. Document is proved that possibly the son of Jamiluddin.
14 also he stated others voters list is at 71. Then in 14 he
And
stated this. He was a minor and in the year, and therefore his name was left out from the electoral roll for the year 66. Because in 1988 only, my lord, it was voters age.
No,
reduced to
Mr.
18.
Mr. Sharma,
My lord.
why do you want the information why it was not recorded in 1965?
71.
If the name was recorded in 1971,
Yes.
and that entry is acceptable to you, that itself shows that this person Motleb is a citizen. Just
Correct.
because Motleb's name was not there in 66 will not take away
Let's see, make-
his entry as a voter in 1971. How can you allow your imagination to run wild to that extent? See the reasoning given, everything is accepted. But the Abdul Moteb was not recorded in the said document, that is 66. Name of Motleb is recorded in 71. Argument is that he was a minor. Why do you have to ask for that argument?
Yes, my lord.
Don't you think an irrelevant question was asked? Answer is not found acceptable, so therefore I reject everything. Declare for it, I do. Say in 71, it is a 25, in the one, so in the 65, it would be 20. Even that calculation is also wrong. It would have been 19.
Yes.
How many
And then
do you
also-
have the voters list in such immaculate manner? That moment a citizen becomes 18 years, automatically his name comes in the vote.
No, definitely, generally people after.
Are you extending that kind of a system? Suppose X becomes 18 years on 1st of March. So on 1st of March, his name will come automatically in the voters list. Are we?
That's
Then it may not come in 66.
Whenever he applies, his name will come.
If it does not come, why do you reject 1971? I heard Mr. Giri tell this. Let's say counsel for the petitioner also heard Mr. Giri. G. Sharma. The petitioner Muhammad Yahi Alam had been referred to the Foreigners Tribunal number Foreign
Jorhat.
Tribunal Jorhat, Assam.
Jorhat.
Jorhat, Assam, Nagaland, for rendering opinion as to whether he is a person who entered the state of Assam or after 25/3/1971 from the specified territory, resulting in registration of FT/SVR/221/14. The tribunal rendered an opinion dated 5/6/2017 declaring the petitioner to be a foreigner. In the opinion dated 5/6/2017, in paragraph 13, the tribunal had held as extracted. A reading of paragraph 13 makes it discernible that the tribunal was satisfied in all aspects that the deposition of the witnesses are corroborated by each other, have been corroborated by each other, and the tribunal did not find anything to disbelieve the deposition of the witnesses. And from the documents and discussions that the tribunal had made in the said opinion, it was proved that the petitioner Yahi Alam is the son of A. Motleb, alias Abdul Muttalib, Muttalib, alias Abdul Muttalib, and that Abdul Muttalib in turn is the son of Jamiruddin. But in paragraph 14, the tribunal had as extracted. From the conclusion of the tribunal in paragraph 14, it is discernible that the name of Abdul Muttalib did appear in the voters list of 1971, but it did not appear in the voters list of 1966. The tribunal deemed it appropriate to put a question to the petitioner proceeding as to why the name of his father Abdul Muttalib did not appear in the voters list of 1966. The petitioner had given a reply that at the relevant time in 66, he was a minor and therefore he did not appear. Based on the answer given to the said query of the tribunal ventured into the aspect that if the Abdul Muttalib was 25 years in 1975, he would have been 20 years in 1966, and therefore there can be no reason as to why his name was not entered in the voters list of 1966. Accordingly, even the entry in the voters list of 1971 of Abdul Muttalib was rejected by the tribunal. Firstly, we notice that if the name of Abdul Muttalib did appear in the voters list of 1971, it by itself is conclusive that Abdul Muttalib did exist in the year 1971, and therefore he cannot be a person who entered the state of Assam on or after 25/3/1971. Even the calculation of the tribunal that in 1966 he ought to have been 20 years. If he was 25 years in 71, appears to be wrong, because Abdul Muttalib could have been 19 years and not 20 years. We have conferred, we have sought for the answer from the Learned Counsel for the Election Commission, whether the voters list are maintained in such immaculate manner that the day a person attains the age of 18, his name automatically is entered in the voters list. The answer given is no, and there is a procedure that is followed for entering the name in a voters list. If Abdul Muttalib was 19 years as of 1966, and the names are not automatically entered upon attaining the age of 18, the question put by the tribunal as to why his name did not appear in the voters list of 1986 appears to be extraneous for the purpose. As the question itself is extraneous, no reliance can be placed on the answer given to such extraneous question, and declare a legitimate entry in the voters list to be unacceptable. In view of the above, the conclusion of the tribunal, as in paragraph 14 of the opinion dated so and so, is set aside. As according to the tribunal, also in respect of all other aspects, the petitioner could prove discharge the burden under section 9 that he is a citizen. We accordingly declare the petitioner Yahi Alam to be a citizen of India, and also that he will be entitled to all such rights and privileges as may be entitled to a citizen. The petition allowed as indicated.
Item 13.
Gonda Mandal. Who is the advocate? Mr. G. Sharma. Are you the G. Sharma?
Lordship.
The counsel
Oh,
for the
no, no,
petitioner
no,
is G. Sharma.
G. Sharma.
Are you the G. Sharma?
No,
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 some
no.
other G. Sharma.
Yes, God.
Very well. None appears for the petitioner when the matter is called. List again. In the event of subsequent non-appearance, appropriate order shall follow.
Item 15.
T. Muhammad. Yes, Mr. T. Muhammad. Hamida Khatun, who is the father?
Father of the Hamida Khatun, namely Asiruddin,
Page number
2728, my lord.
2728.
Periodic patta of a plot of land, my lord,
Patta.
1964. Recorded in the periodic patta, my lord. Asiruddin, son of Umar Ali.
Yes, Mr. Sharma, try to read page 28.
And another, my lord.
Maybe some better copy will be available in the record.
Yes, Lord.
Check up the record. This one is not possible to read.
My lord, another 1970.
Mr. T. Muhammad, we have to go one by one. He Uporot Likha Zila. Deputy Commissioner Prasad Police. What is Asir? What Ali? Asir Ali, son of
Umar Ali.
Umar Ali. This is Topasil. Topasil is in respect of which village?
Tangagaon.
Village Bheragaon.
under, so book police station, but.
Just see the actual original patta. देखिए इसमें क्या हो जाती है 60 something. Mr. Ali and Mr. Sharma, is the original patta available on record? The petitioner to produce the original copy of the patta, the comma, the vernacular.
Zomabandi is here, my lord, next,
No,
page
we-
number 30.
Mr. Mohammed, we don't have the habit of moving around from one document to the other. Let us first,
My lord, this is original.
we have to follow a systematic and methodical manner of dealing with the matters. When we have gone into one document, let us conclude this document first, then go to the other one. If we mix up everything, how can we decide? Okay. Produce the original of this patta. Available, comma, the vernacular version of which is available at page 28 of the writ petition. Patta, original. Not understood. List form, yeah, the
25th.
My lord, it shall be out of station, my lord,
What date?
29, my lord.
29. Item 16.
Yes. Hikmat Ali, who is the father?
Father is Asruddin, page 17,
17.
66.
Pal Hazi, 66. Asruddin is the father.
Yes,
He is the father or grandfather?
my father.
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 Which document will show?
Yes, sir.
Hikmat Ali is the son of Asruddin.
Annexure 5, Lordship, page 21. Lordship.
21.
Different.
Petitioner to show, to produce any relevant document that Asruddin, son of Abbas, of serial number 1216 of the voters list of 1966 of village Pal Hazi, and Asruddin, referred as father of Hikmat Ali, in the voters list of 1994 of village Bolovita, are one and the same person. Next week.
Item 17.
May I please. Lordship, may come to page 67, Lordship. That is
67.
the voters list of
Name is
1965.
Muslimuddin. 67.
Father is there, Lordship. Father, grandfather and grandmother.
Who is the father?
Father is Afezuddin,
Afizuddin is the father.
father.
Songsher Ali, grandfather. Which document will show Afizuddin is the father?
Yes, Lordship. There are voters list, Lordship.
Page number.
At page, Lordship, you will find 71, Lordship.
Page number 71.
72 is the
72. Singudia. Singudia here over there.
this entry, Lordship, in the voters list was
So who is the father you said?
mother and
Afizuddin.
grandmother's name is same, Lordship.
Very well. So now which document will show that Muslimuddin is the son of Afizuddin?
There is one more, Lordship, his admit card, Lordship. HSLC admit card.
Please refer to your best document. Don't take us to all the documents.
The voters list, Lordship, that
Which
one,
document will show that Muslimuddin is the son of Hafizuddin?
that is Lordship will, I have shown Lordship that 1985 voters list, Lordship,
Page number.
page number 71, Lordship.
Are you prepared in the matter?
Yes, Lordship,
Do you want some time to prepare the matter?
72.
Because your answers are not coherent.
Yes, Lordship, Hafizuddin and Muslim Ali is there. In the page, next page, Lordship, 72.
Okay, that same Muslim Ali.
Yes.
Yes, Mr. Sharma.
Yes, Dr. Briman. Briman, Lordship.
Then why don't you say this? You are saying to some other document again. Don't you think if you refer to your best document, it will help you in a better way than referring to all kind of documents here and there? Even here I am. What should you do? Send it back.
Yes, Lordship.
What is your name, please?
Yes, as Lordship.
Huh?
Yes, Lordship.
No, your name.
M. Ahmed, Lordship.
M. Ahmed. M. Ahmed, like I'm saying, petition. Petitioner Muhammad Muslimuddin had been referred to the. What is the judgment?
Jasmine, at page Lordship,
Page 40,
99, Lordship.
99. Referred to the Foreigners Tribunal number 8 Borpeta for rendering an opinion as to whether he is a person who entered the state of Assam on or after 1971. The tribunal rendered an opinion dated 28/11/2018, declaring the petitioner to be a foreigner, being aggrieved the state petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1965 of village Sengelia, police station Horbog, Moja, Domka, Choka, Bosi, in the present Borpeta district, which contains the name of Hafizuddin Sheikh, son of Shamsher Ali at serial 46. Petitioner thereupon refers to the voters list of 1985, also of village Sengulia, which contains the name of Hafizuddin, son of Shamsher at serial 346, and that of Muslim Ali, son of Hafiz at serial 347. And both are shown to be residing in the same house number 180. Petitioner accordingly claims that the burden under Section 9 of the Foreigners Act 1946 had been discharged to prove that he is a citizen, inasmuch as his name along with the name of his father Hafizuddin appears in the same voters list, whereas Hafizuddin Sheikh, name of Hafizuddin Sheikh appears in the voters list of 1965 of the same village. Remanded back to the tribunal to examine the aforesaid aspect as to whether Hafizuddin Sheikh, son of Shamsher Ali of the 1965 voters list of village Sengelia, read with the 1985 voters list of village Sengelia containing the name of Hafizuddin, son of Shamsher, along with Muslim Ali, son of Hafiz, do discharge the burden that the petitioner is a citizen. In doing so, the Home Department of the Government of Assam may also make their verification on the authenticity of the aforesaid two voters list, as well as whether Muhammad Muslim Ali, as to whether the writ petitioner Muhammad Muslim Ali and Muslim Ali of the voters list of 1985 of Village Sengelia are one and the same person.
I have listed.
18,
The opinion at page, she had exhibited her voter list of 1965 in which her parents' name were reflected. But only thing, the vital document link showing the link between her and her parents, that was not exhibited. But we have that document on 1985 voter list.
So difficulty with that. Who is the father?
Narayan Chaudhary Lordship will kindly
Sorry.
peruse page 29, voter list of 1965.
Is 29.
29, voter list of 1965.
is 29.
Narayan Chaudhary and Lokirani Chaudhary are her
And
parents.
Narayan
And
Chaudhary
Lokirani
and
Chaudhary,
Lokirani Chaudhary.
Chaudhary.
Father and mother,
father and mother.
65, village Sohor, Borpeta town. Which document will show you a daughter of Narayan Chaudhary?
Lordship at page 64.
64.
Yes, this was not exhibited, but that is why
We are making it liberal for you. Don't worry. If
64.
you have document, bring it.
64. Voter list of 1985.
Borpeta Road number 8. Borpeta Road.
Voter list of 1985.
85.
Yes. Last.
Who is the petitioner?
Serial
Alurani
Alurani Kormokar.
Narayan.
Serial number 196.
Lokhivala
Father's name?
Kormokar. Lokhivala is that wife.
Yes.
What happened to Narayan?
He died. Father passed away. Mother is still there, but she's a mentally, even she has passed away after the judgment. Narayan Kormokar is the father.
Narayan Chaudhary.
Children.
No. 65 is Narayan Chaudhary, son of Harish Chandra.
Yes, children. Lordship, she, after her marriage, she has become Kormokar.
No, but Lokhivala, Lokirani Chaudhary.
Mother, Lokhinara is the mother.
And who is Lokhibala Kormokar?
Lokhibala Kormokar.
Mother. So Lokhi Rani Chaudhary and Lokhi Bala Kormokar may be different person. The petitioner to examine as to whether Lokhi Rani Chaudhary at serial 143 of the voters list of 1965 of village Sohor Borpeta Road town and Lokhi Rani Chaudhary, wife of Narayan Chaudhary, and Lokhi Bala Kormokar, wife of Narayan at serial 195 of the voters list of 1985 of village Borpeta Road number 8 in Borpeta Road, ward number 8 are one and the same person. Let's next week. Just see what material is there. Their daughter after marriage may become Kormokar, but the wife will remain Chaudhary. Wife.
What I've been told is
No,
the
I know.
ladies.
That's why I said you examine, verify, and tell us.
Lordship,
If you have more materials, bring whatever you have.
Lordship.
Any document. to
Any
establish.
document. Lordship. Okay.
Item 19.
Mother definitely after the demise of the father did not remarry.
No. Mother passed away after this.
Understand. The daughter after marriage may become Kormokar from Chaudhary,
Yes,
but the mother cannot become a Kormokar. Mother will remain a Chaudhary.
yes. What are
This
some ladies?
difference we are finding.
Some ladies insert Kormokar in, that is what I will be not.
Please, please look into it, tell us. Yes, next item. 19.
May I please your lordship? Petitioner's father is Mohanlal Ghosh. Mother is,
Ghosh.
yes,
Mohanlal Ghosh. Which page?
page number lordship, page 62. Voters list of 1959.
Voters list of
1959.
1959. Page number
62 lordship.
62. Are you sure? It will heavy, WBC 1073.
Yes, 1073 lordship.
62 is published by the Life Insurance Corporation. Please look into it.
Yes, sir.
Maybe some.
Yes.
It was 62.
This will be 61 lordship, if
Huh?
I'm wrong lordship. This is 61 lordship. 59 voters list is page 61.
Please check. We'll take
Yes,
up the next
Lordship,
item
yes.
and just. And if there is any correction required, make it.
Yes, sir.
Item 20.
please. My lord, the father's name is that is 14. Voter list of 66. Romizuddin is the father.
ডাঙৰ নোট বনাইছে
13 is the translated copy.
পারবে না? Somebody heard this matter earlier.
My lord,
Did some other court hear this matter?
my lord, the other court,
No, one long notice.
I don't know, my lord, how that can come up, my lord. I have seen, my lord, some writing is there. How that has come, my lord. I cannot say.
Anyway, let us adopt our own procedure. Riazuddin, who is the father of the?
My lord, at page 13,
Yes.
vernacular at page 14, my lord. Romizuddin is my father.
Page, just a minute, page 14. Ramizuddin is the father.
Father. Haitham
And
Nasa is
Ah.
own mother. Lohizan is the stepmother.
Lahizan is the mother.
A stepmother.
And Haizan,
Haitham is own mother.
OM, own mother.
Yes, my lord.
Lahizan SM, stepmother.
My lord.
And Ramizuddin, father.
Father.
66 village forest Salbagan.
For linkage, my lord, two
Mm.
documents were produced.
No, which document will show that Ramizuddin is the father?
My lord, at page 21, 22 is the original copy. It's a domicile certificate. My lord, he was seeking appointment in the defense, and for that purpose, this
He
certificate
was
was issued.
seeking appointment in
For defense, my lord. Army as an army.
defense.
My lord. This is to certify that Muhammad Riazuddin, son of Muhammad Romizuddin, village Salbagan, post office Nandapur, PS Huza in the district of Nagaon, Assam, is known to be residing at the above mentioned
Yes,
address.
sir.
Okay, but petitioner is resident of Milik Bosti Lordship.
Hmm?
In the cost title. Petitioner is resident of Milik Bosti Lordship.
Not Salbagan.
No, no lordship.
Then we send it back, whether the other, what's the other village you said just now?
Salbagan.
No, not Salbagan, other one.
Milik Bosti.
Whether the Riazuddin of Milik, that one, and Riazuddin of Salbagan are one and the same person. Heard Mr. A.R. Sikdal, Land Counsel for the petition. The petitioner Muhammad Riazuddin had been referred to the Foreigners Tribunal. Foreigners Tribunal Hojai at Sangotev Nagar for rendering an opinion as to whether he is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT bracket H, not bracket H, stroke H, stroke case number 101 stroke 2014. The tribunal rendered an opinion dated 26/9/2019 declaring the petitioner to be a foreigner. This being aggrieved, this writ petition is instituted in the writ petition. The petitioner relies on the voters list of 1966 of village forest Salbagan, police station Hojai in the present Hojai district, which contains the name of Ramizuddin, son of Rahim, at serial 15, and that of Lahijan, the wife of Ramiz, at serial 16, and Haitham Nesa, wife of Ramiz, at serial 17. It is stated that, claimed that Ramizuddin of the 1966 voter list is the father of the petitioner and Haitham Nesa is the mother. To substantiate that the petitioner is the son of Ramizuddin of the 1966 voters list of village forest Salbagan, reliance is placed on a domicile certificate issued by the additional district magistrate Nagaon dated 25/8/2000, when the petitioner had participated in the selection process for appointment in the Indian Army, that Muhammad Riazuddin is the son of Ramizuddin of village Salbagan in the under Hojai police station. Accordingly, a claim is made that the petitioner had discharged the burden under Section 9 of the Foreigners Act 1946 that he is a citizen of India. But Mr. G. Sharma, Land Counsel for the Home Department of the Government of Assam, has stated that the reference is against Muhammad Riazuddin of village Mikir what?
Milik Basti.
Mikir Basti
Milik Busti,
of village Milik Basti.
Salbagan and Milik Busti is same, my lord. That has been recorded in page 43 of this.
Milik Basti, also under Hojai police station in the Hojai district. Full stop. What kind of a document is page 24?
43, my lord, the judgment.
No, 24.
24.
Where is the original of 24?
24.
A full stop. For the purpose, Mr. G. Sharma refers to the Annexure G certificate dated 1/8/2012 issued by the President of Milik Basti Gaon Panchayat, which says that Riazuddin, son of Ramizuddin, is an inhabitant of village Salbagan bracket Milik Basti.
Mr. Sigdar, come to page 24.
My lord, yes, my lord, 24, the Panchayat certificate.
Yes, here village is a Salbagan within bracket Milik Basti.
Yes, my lord.
Then come to page 25. Here village is only Milik Basti. Is it correctly translated?
My lord, the translation is wrong, my lord. Admittedly wrong, my lord.
No, it is a misleading
Yes, my
document.
lord. Translation is wrong. My lord. My lord. My lord, I was subsequently engaged in this case, my lord.
That's all
My
right.
lord,
No, we are not saying anything personally against you,
My
but
lord.
that translation
Lordship,
appears.
a direction to verify.
And not only that, the wrong translation is definitely with a misleading intention, so that
Yes.
it is consistent with the voters list of 66, because that is of Salbagan.
Salman.
So you just add the word Salbagan.
But the all documents, my lord, academic
Understand,
certificate,
but
birth certificate,
this is-
everything is Shalbagan, my
But
lord.
this is not a very good practice. Who had filed this petition?
My lord, it is by the Panchayat authority.
No,
President
who
of-
had filed this petition? Akram Hussain
My
Alamgir.
lord, my lord.
You are the person. Why did you do a correct translation?
In 43 pin, Salbagan and same.
But what do you mean by translation? Mr. Alamgir, translation and does not contain any interpretation. Whatever it is, a translation cannot incorporate interpretation or clarification. Translation is translation. Exactly. Only the language changes, not the contents. Sorry. Not good. We don't like this kind of behavior. Whatever you say. Be fair, take a order. And within the realms of your fairness, we are trying to help you in each and every manner possible. If you don't notice, we notice, still we are passing orders in your favor. But don't make this habit. And this is mischievous because the word, mistaken word has a relevance.
My lord.
Why didn't you add some other name if it is by mistake? Why did you write Salbagan? So link up with your 1966 voters list.
Nandapur, Salbagan.
Well, he has some other documents, my lord, birth certificate.
No, no, we are not on that. He is or he is
Same,
not.
madam.
We are only on the translation.
My lord.
We'll impose a cost.
My lord, I think, my lord,
Not Mr. Sigdar, on Mr. Alamgir, because we were not there. We had noticed. We had noticed that Mr. Sigdar was not in the matter when it was filed. Nor he was there when it was moved also. Moved it is AM Alamgir. You pay a cost. You have to.
I never do that.
Sorry.
I may not do like this, but my fault.
You are on future. We are on present. Present, we have already done it.
Sometime other also try to make complaint with me.
We don't understand one aspect, why mistakes are linked up with some legal right, otherwise you are not entitled. Why the mistake cannot be in some other manner, which will not create any legal right. When the mistake is directly related to accrual of a legal right, which otherwise you may not have, this is not mistake, this is deliberate.
Thanks.
You could have written any other word. Instead of Salbagan, you could have written something else. Why did you write something else? Why did you write only specifically Salbagan? When Salbagan can be related directly to the 66 voters list. No, we are not giving anything. You just pay a cost. We are recording it. You pay the cost. It has to be.
my lord, maybe excuse my lord, for the as a first time, my lord, teasing them.
But first times are being repeated. Maybe.
I have also not noticed, my lord, while leave is handed over to me, my lord.
It is noticed that the English translation of the vernacular certificate at page 25 is at a variance from the vernacular. Petitioner to rectify the mistake and correct the.
My lord. My lord. My lord.
At least you wait for one.
My lord.
Item 19.
May I please your lordship? That is page 61, lordship.
61.
This is the voters list of the father of the petitioner, lordship.
Voters list of the father of the petition.
Yes, lordship.
Page 61.
Yes, lordship.
Huh. You have Mohan, what?
Mohanlal Ghosh.
Mohanlal
Ghosh,
Ghosh, son of Boikuntha,
Boykunta,
village.
Goreshwar.
Goreshwar. Thana Rongia.
No, Goreshwar only.
Thana is Rongia, I think.
Or Romia.
On extreme right.
No.
Rongia.
And then page
Goreshwar to
63, lordship.
Oh, he অকমান আগৰ যে আছে। আগৰ he পুৰণা কৰিছে। This is of which year?
59, lordship.
Where do you find the word 59?
Original is there in the record, lordship.
59. No, this is. What is the 59?
Little bit blur.
Now, which document will show
So
that
I'm a
Nomita Ghosh is the daughter of the.
literate women.
Mhm.
So my mother has adduced evidence who has casted vote along with my father in the year 1971.
1970.
1.
Page number.
71 is page 66, lordship.
Mohan Mohan Pal Ghosh and Usha Rani, that one.
Yes, Usha Rani Ghosh is my mother.
And evidence of Usha Rani.
Usha Rani is there and
Usha
even,
Rani cross-examined.
yes, Lordship, and even one of my elder brother, he works in IB. And he also has, from West Bengal, he came down to adduce evidence. And he also has adduced evidence before.
Madam Ghosh,
Yes,
this
Lordship.
IB is double-edged. Your brother in the IB,
Yes, Lordship.
it is double-edged. It's
Anyway.
double-edged because if he is in the IB, it will give you some more credibility.
The foreigner,
Just a minute, it will
Yes,
give you
sir.
more credibility. But if he is a foreigner and he has entered IB, it is a security situation for the state.
for him,
Huh.
I mean to say.
Therefore, I
Lordship,
said double-edged,
Yes,
it is
Lordship.
more dangerous.
Why I want to state this, Lordship, reason is that a person who is a government servant won't come down from a different state if he is not my elder brother to adduced evidence in my favor in one of the district in Assam. And my brother's residential
So what
certificate,
is the basis of that statement?
residential certificate.
What is the
also.
basis of that statement?
Because it's not a projected brother. I mean to say that this is not a
No,
projected brother.
Even a projected brother, if he has reasons for his own, not only from another state, he may come down from another country also. That depends on what kind of compulsion is there.
And this, there is no rebuttal to,
For that mother's evidence.
yes, Lordship.
Yes.
Mother's evidence is at
page
page
number? Hmm?
39, Lordship. Page 39 is the mother's
What is page
evidence.
68? Husband possibly. This is the marital village, I think.
Yes, Lordship.
Nomita. Page number 79. Sorry, page number
Page 39.
13. Yes, Mr. Sharma. Why should DW2 be disbelieved?
Yes, Lordship.
Or you want to answer?
No, no.
Lordship. Lord,
Why should these DW2 be disbelieved?
I think he was not, she was not cross-examining Lordship.
Cross-examine,
Don't cross-examine.
cross-examine.
Cross-
It's there in the record. I have not annexed. Cross-examination was done. Cross-examination by AGP, not by the, not only examination under 165. It's cross-examination was done.
Matthew auction is there. The land of problem has been auctioned by the civil court.
Yes, cross-examination. Usha Rani, cross-examination. Record number.
What is called trading? Take trading. It crossed. Was this evidence demolished that Domita is the daughter of Usha Rani? No.
No, Lordship. May I read whatever I have translated copy I have with cross party? 71 of vote and vote দিছে, বাপে কারো মাকে ফেলো। ইয়া করছে।
আমার অ্যাড্রেসটি কি দিছে বা ওই যদি অ্যাড্রেসটি নিয়ে আছে এই ঘরের সঙ্গে Hotels discount to produce would say review. Gorisol Betagao no. Gorisol.
Oh.
Under Gorisol police station. Another but this is one. Our dinner 60 at our police station was jurisdiction was much bigger. Area to মাঝে মাঝে ভাগ করি আছে এখানে এটা করে সর হবো পারে পুলিশ স্টেশন Yes, Mr. Sharma.
Yes, Lokship may pass order.
Let us close this case here only. Because murder was thoroughly crossed. And one 83-year-old person comes and says that so-and-so is my daughter.
Yes.
No reason to disbelieve that. And not only that, everything else this person said corroborates with the other materials. That is even more important. It's not that only one sentence she said that so-and-so is my daughter. She said a number of things and all other aspects she says corroborates with each other, including the statement that Arun Ghosh is her son. And Arun Ghosh comes and also deposes.
Yes. Yes.
Heard MSB Ghosh and counsel for the petition. Also heard. The petitioner Namita Ghosh was referred to the Foreigners Tribunal number 2 Nagaon for rendering an opinion as to whether she is a person who entered the state of Assam on or after 25/3/1971. The tribunal rendered an opinion dated 25/6/2019 declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of village Goresor in the of the then Kamrup district under Rongia police station, which contains the name of Mohanlal Ghosh, son of Boikuntha at serial 735. The petitioner also relies upon the voters list of 1971 of village Goresar, post office Tamulpur, which contains the name of Mohanpal Ghosh, son of Boikuntha at serial 1869, and that of Usha Rani Ghosh, wife of Mohan at serial 1870. It is claimed that Mohanlal Ghosh is the father of the petitioner and Usha Rani Ghosh is the mother. Usha Rani Ghosh had deposed before the tribunal as DW2, wherein it has been specifically stated that that she married Mohanlal Ghosh in the year 1950, and out of the wedlock, 8 children were born, namely Arun Kumar Ghosh, Anita Ghosh, Namita Rani Ghosh, Sabita Ghosh, Ajay Kumar Ghosh, Rita Rani Ghosh, Arjun Kumar Ghosh, and Rinku Ghosh. Evidences have also been rendered by Arun Kumar Ghosh, who is also an employee in the Intelligence Bureau, as well as Ajay Kumar Ghosh, that Namita Ghosh is their sister. The state authorities through the Home Department had cross-examined DW2, wherein also the same deposition had been rendered that Namita Ghosh is the daughter of Usha Rani Ghosh. And in the cross, the respondents could not rebut the evidence led by DW2 in her chief that Namita Ghosh is the daughter of Usha Rani Ghosh. All other statements made by DW2 in her deposition, corroborates with the other materials that are available on record. In the circumstance, we have no reason to disbelieve the evidence of DW2 that Namita Ghosh is the daughter of Usha Rani Ghosh. And full stop. As Usha Rani Ghosh herself could prove that she is the wife of Mohanlal Ghosh of village Goresar, whose name appears in the voters list of 1966. We accordingly declare the petitioner Namita Ghosh to be citizen. The Namita petitioner shall be entitled to all such rights and the petition allowed as indicated.
Deeply.
26 to 28 for orders.
Who is there in for the respondents? Yesterday someone appeared. Dina. Is he available? You're appearing in this matter that WP criminal 11/20/22. Dina. No, we heard it is Dina, but as Mr. D. Majumdar was coming forward, we thought maybe for the other one. Other one you have already completed. You want to leave this? Leaving 20 minutes early will also be a big help. No, we don't do that. We desire that you be comfortable. So, Mr. Mahmood, yesterday we heard the criminal petition 01 and 06.
Yes.
Both are in respect of the same deceased,
Yes.
and one is by the mother and son together, and one is by the mother. One was for
One was for causing high level inquiry.
inquiry, and other one is for compensation. We combine the two and make it to be one petition.
Yes.
And hear it. Madam Das, if it is Mr. R.K.D. Chaudhary and Mr. Dina, You'll have to face this kind of situation at times. You don't know in which court they have gone by now. So let us begin with Mr. Mahmood. You take notes. Whatever he says.
We take in 11 or
No, first we take up 01 and 06. Because custodial death cannot be one common hearing.
01 was filed, my lord, by Saiful Islam,
No, we don't.
who is the elder brother of deceased.
No, we have already heard it yesterday. That's all. Now come to the main issues.
Now, after the death of his brother.
No, first you have to give us the dates.
Hello?
First, you have to give us the dates, when the person was taken into custody, when he died, what circumstance he died. You are
He
prepared
was
or not?
arrested on 27/9/21.
27/9/21, he was taken
Arrested.
into custody.
In connection with Borpeta, US case number. In connection with Borpeta case number.
On which date?
Borpeta case number, that lordship making case 27.
No, no, on which date he was taken to
Yes,
custody?
he was arrested on 27/9/21.
27/09/2021. In connection with?
With Borpeta PS case.
Mr. Mahmood, if you're not totally ready, we can hear it on some other day.
2109.
Which police station?
Borpeta PS case number
Borpeta.
2109.
Borpeta PS 2101
09
of
of 2021
21.
under section 365.
I think we have called for the scan report of this one. Who is the person who died? Sahabul.
Hasibul Islam.
Huh?
Hasibul Islam.
Hasibul.
Hasibul. Thank you. Yes.
Hasabul.
Hasibul.
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 No, no, we are reading the FIR. FIR one name is the Hasabul.
It was written by
Same person.
private, yes, same person.
Hasabul Pita some Ali.
Hussein Ali. Hussein Ali.
Hussein Ali. I might be saying. Who wrote this FIR?
Heddus Ali. Heddus Ali.
No, no. Somebody.
Yes,
who- It is an FIR by Fidus Ali.
Yes.
But who wrote the FIR?
Writer has given his signature. Yes. And one oath is also there.
Where is it?
Second page, last column, the FIR contains 2 pages. Second page, সত্যপাঠ উপৰোক্ত উক্তিবোৰ মই কোৱা মতে লিখা আখৰে আখৰে সত্য জ্ঞান বুজি তলত টিপ সহি কৰিলো।
No. Tipsohi is of Fidus.
Yes, yes. No, just left side of that column. One signature is there. Possibly that is the signature of that writer.
That dated 27/9, that one.
27/9.
Writer.
Possibly that is. Written by. These petitioners, they are also accused in this FIR. Saiful Islam and Kadmanu. In that case, FIR has been submitted.
You have the complete GD3 book.
I have asked them to provide the GD entry as regards registration of this FIR. I can produce the case diary and the entire case.
I think we will need the complete
I can.
GD entry.
Logic.
One, two, three. If the come to the first page of the FIR, Asami, Hasabul Islam, Peter Hussein Ali, Jamaluddin, Peter so and so,
Yes,
Saiful Islam so and so,
yes.
Kadbhanu Swami,
Hussein Ali.
Hussein Ali. So the Hussein Ali's entire family.
Family.
This appears to be a 365 case. Somebody's daughter may have been taken by
Yes.
somebody's son.
Yes, madam.
Background appears to be like that.
Yes.
Now,
360.
look at your FIR, column 7.
Yes, madam.
It is again Sahabul Islam, son of Hussein, Jamaluddin, son of Hussein, and 2 others.
This Hasabul has been wrongly written.
So the person filling up the FIR
Wrongly written.
interested in something else.
True. This should be Hasabul.
Piece of letter, FIR will find. So you can so many years, you can basically when you say. That was এতিয়া থানার অন্তর্গত জাতি অনেকে স্বামী অনেকে এগেন্সি ঘুরি বসে সেখানে মানে they did not waste any time. সেটা হচ্ছে 1/3 হেভি আর লোকটা রেজিস্টার করা হয়ে গেল। Mr. Nath, the FIR and the Azhar looks too perfect. The FIR means the information that filling up that form, and the Azhar, they are matching so much with each other that it is looking more than perfect.
His
Well.
Why I am telling
Well,
you,
well versed in writing the FIR.
why we are telling you, এতিয়া থানাৰ অন্তৰ্গত
Yes.
কিবা চাম মাৰি গাঁৱৰ নিবাসী ফেৰদৌছ আলী পিতা সোয়েনসো এক
Daukmari.
একে গাঁৱৰে নিবাসী অমুকৰ বিৰুদ্ধে দাখিল এজাহাৰৰ মতে অমুকক হেৰি কৰা হ'ল
He has also said
হা
Sahar.
this happened at 1:30 and admittedly this is a person, did he pre-prepare this FIR written by somebody or he came to the police station and the police had converted to a written ezahar? Who had done it?
Who has written by somebody, but the name is not there. On the signature, from the signature, it cannot
Understand.
be, it cannot be
So
ascertained.
if the person comes to the police station at 1:30, he will take at least 15 minutes to write this ezahar there.
Hmm. Sure.
So your recording of the FIR cannot be 1:30.
130.
It
That-
has to be at least 10-15 minutes subsequent to 1:30.
Or at two, my lord.
So that's why I said it is more than perfectly matching.
Hmm.
Hmm.
They, information received time they have mentioned at 1:30. They said in the first page,
No,
information
it's
received
not that.
at 1:30.
Information received, not information, information received at 1:30.
Yes.
Information received by what? Oral information.
No, my lord,
Information will be complete when the ezahar is written.
serial number 12.
Hmm.
First information contents.
Original FIR enclosed herewith. So this person, Ferdous Ali, he went to some ezahar writer before coming, writing in that manner, putting his thumb, or he comes to the police station and then the ezahar is converted to written form. If that is so, the two timings are not the same.
Two timings.
Hmm.
In that case, it will not same. It will not same.
Yesterday, which page you referred, Mr. Mondal? Sorry, Mr. Mahmood.
Where?
Yesterday, you referred to some ezahar.
Yes, so that
I
is,
think page
this
27.
that is page 24
No, page 27.
and certified copy and translated copy page 21.
21. eh?
First one. And second affair which we lost after the so-called suicide of this Hasibul Islam, that is melodied
এইটো চাব বিচাৰিছিলো, এইটো।
page 27. Our affair.
From which copy of the FIR you made the translation?
Our affairs. Page
No,
27.
no, the page 21 English translation.
Yes. Page
It is
20,
made by the petitioner from which copy? Page 20?
page 21. Of
No, no, 21 is English.
of WPC criminal 122.
Understand. Page 21 is the English translation.
Yes.
Where is the vernacular?
Vernacular is at page,
Hmm.
that is page 25. It is just from 24, certified copies.
Who had put this endorsement seal 28/9/2021? Page 25.
Yes.
Come to page 25.
Page 35. ma'am.
Page 25.
Yes.
One endorsement is there, seen 28/9/2021.
25.
Who's page 25?
Page 25.
Hmm.
Yes,
Is that a name, Mr.
that is. Hectus Ali, that is, there is the case against deceased Hasibul Islam. I am clarifying the matter.
From where did you make the photocopy of page 25? Let us see.
20.
Original to
Page 25 is a photocopy. Let us see the original.
original certificate copy.
Original certified copy.
Original certificate copy is not with me. But there are original Xerox copies.
No. When your client came to you, you made a photocopy and made an annexure.
Yes,
What was given to you? This one.
but that is photocopy. Original copy perhaps given to Police Accountability Commission. Their name is Hasibul Islam is there, the top.
Yeah. This is basically a copy of your petition only. We don't need this.
But now the original has been brought in.
Hmm. Did you move any bail petition next day?
No, my lord, when he was killed in the district.
No. Suppose he was arrested on 27/9.
Yes,
On 28/9, was any bail petition moved?
no, bail petition was moved, not moved,
Not moved.
but when he was killed, then.
No. On which date he was killed? Date of death?
Hasibul Islam was arrested on 27/9
On,
and.
on which day he died?
He died on 12/10/21.
12, that's a long after. Why will they give a certified copy? Certified copy given for every day. যদি এখন বলছে ম্যাজিস্ট্রেটে ইয়ারে এই স্ট্যাম্পের মাধ্যমে কি সবল বলবে এখন কেন সবল ফটোকপি একটু অরিজিনাল হয় এখন যদি সে আরে ফটোকপি হয়ে পড়ে এখানে ফটোকপি টিকেট মানে মানে ইচ্ছে সাবজেক্ট কপি Police certificate copy to go before by sort of original certificate copy. Certificate copy is somebody will have to apply. Have to take over. Mr. Nath, one thing we are having difficulty. If this is the photocopy of the original Ejahar that was lost before the police, whosoever may have written, this is dated 29/9/2021. Okay, now you come to page 26. 26 of the writ petition.
Yes, madam.
You notice that some code stamps are there on the
Yes.
left hand side.
Not yet.
Stamps are there means this is a certified copy. Page 26 is the photocopy of a certified copy. And that scene must have been given by the Chief Judicial Magistrate.
Yes,
Just see, just below 26,
yes,
a part of the seal is there, Chief,
see,
must be Chief Judicial Magistrate.
lordship.
If this is presented before the Chief Judicial Magistrate at the time of production of this accused on being arrested, why did the police give a certified copy? Why the original was not given?
No, no, police has not given the certified copy, my lord. My lord, please-
Mr. Nath, please understand the question. From where did this document come from, page 26 then?
Page 26, they have applied the certified copy on 30th of September. On 30th, kindly,
Understand, then how can the Chief Judicial Magistrate give an endorsement seen dated 29/9/89?
my lord, after register,
See the sequence. Once a man is arrested on 27, there is a endorsement by the Chief Judicial Magistrate seen. Okay, and that is dated 28/9. That means the next day.
next day,
Two possibilities are there. One, the petitioners have applied for a certified copy, made a bail application before the magistrate simultaneously at the time of production. Or there is no bail application, but only production by the police before the Chief Judicial Magistrate. Okay. If it is only production, there is no occasion for the police to present a certified copy of the Ezahar before the Chief Judicial Magistrate. And this is an endorsement by the Chief Judicial Magistrate on 28/9. That means this document was placed before the Chief Judicial Magistrate.
no, after,
If it is placed in course of the production, either a photocopy or any copy of this Ezahar ought to have been presented, not a certified copy of this.
definitely,
So therefore, we are trying to find out why a certified copy containing the endorsement of the CJM was there on 28/9.
my lord, after,
Mr. Mahmood, we are asking, did you move a bail on that day?
uh,
If you moved a
have-
bail,
I have
there
not-
is a possibility because the accused may have taken a certified copy of the Ezahar and moved a bail petition. But
I have to take instruction.
But when, again, as per our experience goes, when a bail petition is moved,
Yes.
CJM does not put his endorsement seen in the Ezahar.
my lord, after registration of the FIR, the record goes to the CGM code. And in the CGM code, my lord, he used to,
Mr. Nath, we are precisely asking you that question. When the record goes to the CJM court on a regulation basis,
yes, my lord,
you don't send the certified copy of the Ezahar.
no, certified copy, certified.
You can
copy-
send only the photocopy of the original
Yes,
Ezahar.
yes,
But page 26 containing a stamp on the left-hand side means it is a certified copy. Plus, the handwriting of the FIR and the handwriting at page 26 are at a variance. This is not the same handwriting. So itu copy নহয়. And mind you, we are now examining a case of custodial debt.
yes, yes,
Questions may come up when the person was arrested and when the case was registered. This is one of the most valuable aspects in custodial debt. If the arrest and taking into custody is before the Ezahar even was lodged, it is possible that this GD entry is altered on 130. Someone comes and makes a complaint to the police. My daughter is taken away. By whom? So and so. Get hold of him first. Give him some nice treatment in the police station. When things appears going a little dangerous way,
registered.
get an FIR filed and get it registered. But in the meantime, it is already 28/9. By the time these things happen, we have to cover up. To cover up, you get somebody register an FIR on the previous day itself. as if we have acted pursuant to that one. So these discrepancies are a little vital aspect for us in this proceeding. Had we been a bail proceeding, had we been something, we would not have put you these questions.
I'll examine. I'll
Get the entire records or in original.
check.
The entire records in original of Bilasipara PSPS number 2109-2021, along with all such materials in origin that it may contain as regards production of the accused persons before the court of the learned chief judicial magistrate, etc., be also produced before the court.
May I say one thing? It will be Borpeta PS case number 2109, not Bilasipara. 2109, 21, and may I pray that another connected what affair we have lost.
That
That
is, I think, already here.
That scan copy.
Mr. Mahmood, let us go step by step.
Lordship.
Don't mix up everything and let us first be satisfied ourselves that the circumstance of taking into arrest, taking into custody was done in a legitimate way.
Yes. That may can be.
Mota. কিন্তু এখন যদি দাগ করতে একটু হয়েছে অরিজিন কোনো ডেটে থাকে একটু ফটো ফটোকপি করেছে অরিজিন কিন্তু ফটোকপিটা আপনার স্ট্যাম্পে না থাকে Stamp is the most confusing. Stamp. Code stamp. Sign a magistrate or to endorsement to originally put this. Very hello, library. যদি এনেকা এখন কাগজত দিছে তার পিছত ফটোকপি কৰি তাৰ সার্টিফিকেট কপি দিছে আৰু যদি নহয়
এইটো কাৰ্বন কপি
similarly, the records of so from the court of the learned chief judicial magistrate,
Yes.
Bongaigaon, Borpeta be also produced list Monday. Court record to kone call koribo. Registry call koro.
from the registry will be given.
Kind of কোথায় আছে কালি কোথায় দিন মানে little after Monday দিন লাগবে Tuesday. We also called through the registry.
Part had it, otherwise everything will go on.
Sorry.
Part had.
No, it is-
We are yet to hear. Mr.
Actually,
Mao.
when it comes to another court, these points may not be.
No, it is shown as part height.
Part
It is shown as part height.
then
Already
already on 16, 5 minutes.
Do you expect the court not to be there on the Monday?
Not my intention.
Yes, when do you have to give your reply? Monday, do you? But Monday we'll
Yes, yes,
conclude it. We can't go on
Yes, Lord.
prolonging this matter. That matter. The further thing. Monday.
yes.
I think we have completed, Mr. Nath, from, oh, you were not there. Muzumdar was
Yes,
there, I
sir.
think. Mr. Muzumdar there, sorry. We will name.